So will there be like bigger trucks, like will we truck table at the other one?
Yes, we usually have a cut table at the other one.
Oh, I didn't, because I heard you guys, I remember you guys told me that something about like regulations where like where you couldn't have press tables here, but I didn't realize you changed rooms. I thought they just did
No,
construction.
they now, because we had construction permits for the county, direct permitted on the ADA.
Oh,
All
okay.
things are expanded.
Yeah, I see. So when you go back to the old one, you'll have more too. When do you guys think that is?
So we should be here by next week. But
Okay.
we can completely issue a red zone.
Yeah.
But if you want to go to the room, we'll be able there for press.
Oh, that's the old one.
Yes.
Oh, I thought it was the,
There'll
okay.
be occasional special space, but not always.
Okay. Oh, thank you. Hey, I was just talking to Stephanie. Did you guys?
Oh, we're here.
Oh yeah, no, I know. I was just curious if you guys knew about. I was putting you up for it to see if anybody that should testify or not.
Yeah, you.
Good. Oh, okay. Okay. Cool.
But I'll do it.
All right. Yeah. You guys have a good. You need the power on that?
You can actually now. Thank you.
Did you not know there was a
Didn't
power?
have, yeah.
Is that what you use your phone for?
I usually take it when I jog, like I try to do street or whatever, and it's pretty awesome. Yeah, I should have it on my phone. Probably before I have to leave the office.
Yeah.
It's very funny, but
Oh yeah, I didn't try to the border stuff all the way to the past the border somewhere I thought.
yeah.
But it's always like 45 minutes.
Yeah.
Oh,
Yeah. They're leaving. We'll be off.
No, I mean the line.
Oh, you're
No, you're fine. Yeah. That's part of it.
there's been so many professional lawyers business combinations.
Yeah, I know they're all, yeah,
They all probably like,
yeah.
and they've done more
Yeah, it's gotta be, I mean, it's just very low, on the overtime, you
But it probably will, like,
yeah,
I'm sure.
okay.
But that was kind of the key there.
Right, exactly.
So yeah, I mean, anytime I feel like there was a day a week that I would catch a call from that time, I'm sure, you know, they would just get out about it, you know, and pull over. And
Yeah,
like,
exactly.
sometimes they will try to overturn it, but like that.
Well, you know, I didn't understand what kind of issues we have had. They were like, oh, it's not like the next week, much more information.
That's true. What was the other one? Basilica hasn't been issued
Yeah,
yet,
that's
right?
it.
But there's another one that was issued.
I think that's the secretary.
That was really great.
I think so, yeah. I think that was there.
Yeah. Is Persuader heavy contract or monthly fiduciary?
Yeah, I think it's really good fiduciary.
Even if that didn't have enough contract, like they only had like 54 instead of 27 or something.
Yeah, it has 3 dashes.
3 different guys.
Yeah.
I think they sometimes they are inconsistent.
Yeah, they're in there.
So I wouldn't be surprised if it's not.
Yeah, it's not. Yeah, because we're limited to get managed business. But they do have. Yeah, I think so. And then it's kind of slowed down so much that we feel like it's not like walking through it.
Yeah, mid August.
Yeah.
I can believe that. That's when people have like all their cars run off.
Yeah.
At least we're putting stuff aside to be able to buy the title and everything. You're gonna have to take a roll here and bring it back. At least have that aside.
Yeah, I think it's typically the holiday time. Well, we're kind of, I do really appreciate it. I think that all of this, what about you?
I guess that's the case that it used to be, I live that way.
Oh,
And so,
right, okay.
yeah, and so it used to happen a lot of times that the volunteers that I would work at had to get into accidents.
Yeah.
A lot of people had. And so,
That makes sense, yeah.
but yeah, you know, I got up there and just in case something happened.
Yeah, no, you don't have to. You don't have to. Yeah, I appreciate it.
Oh, yeah.
Yeah, and that's really good. And
Yeah. At least you don't have to, at least from, I mean, for the most part, not
yeah.
not for years. Oh, yeah, I know. I know they're so it's not be as bad when they start to crack.
No, stop when you get really
A quorum being present, the Committee on Education and the Workforce will come to order. I'll recognize myself for a brief opening comment. In July of 2011, Chairman Walberg held a subcommittee hearing to examine whether the Fair Labor Standards Act was meeting the needs of the 21st century workplace? And the answer, of course, was a resounding no. We learned the rules implementing the law are too complex, bureaucratic, and outdated. Trial lawyers profit while workers are denied their fair share under a broken regulatory system. That is precisely why this committee, more specifically Republicans on this committee, have repeatedly called for a responsible effort to streamline and modernize federal overtime rules. Workplaces are more dynamic and innovative than they have ever been, and the needs of today's workers are much different than for those who worked when the law was written more than 75 years ago. Workers and employers have a better shot to succeed when federal policies reflect the changing realities of our economy. The Department of Labor had an opportunity to build consensus around a set of responsible reforms that would have garnered broad bipartisan support. Yet the Department chose, once again, to take an extreme partisan approach that will hurt the very people they claim they want to help. This rule will disrupt the lives of countless individuals and do nothing to remove the regulatory landmines that are harmful to workers and employers. That's what small business owners, college and university administrators, state and local officials, and heads of nonprofit organizations have warned about. But these warnings were ignored. The Department ignored the voices of those who must implement this rule in their workplaces, on their campuses, and as they serve the needs of people in their communities. Instead, the Department listened to the same progressive voices who have been wrong for so long about how to address the challenges facing working families. The same voices who claimed a $1 trillion stimulus bill would create jobs and deliver a strong economy. It didn't. The same voices who claimed a government takeover of health care would lower costs and protect the health care people liked. It hasn't. Same voices now claim this overtime rule will provide a pay raise for millions of Americans. It won't. The regulatory onslaught under this administration is unprecedented. The President and his liberal allies have advanced new rules governing retirement advice, health and safety, energy, union organizing, federal contracting, financial markets, health care, and wages. Still, there are those who can't understand why the economy is anemic, or why job growth is sluggish, or why wages are largely stagnant. Now we have an overtime rule that will do more harm than good, particularly for lower-income workers and younger Americans. Chairman Walberg has led our efforts in this area for years, and where is Chairman Walberg? There he is, and I would now yield to him the remainder of my time to explain in more detail the cost and consequences of this rule.
I thank you, Mr. Chairman, for recognizing me on this. This is an important issue, and we've spent significant time on it with the hopes that someone out there dealing with this would listen, and listen to reality. I mean, today I receive a copy of a letter sent out by professors and nonprofits, none of which who have anything to do, as far as I can tell, with establishing a budget and dealing with paying people and making sure institutions continue. And in fact, what I see here, professors of theater and others, no wonder we've got the problem with misunderstanding what realities are in making sure that people have opportunities for expansion, opportunities for experience, opportunities for resume building, opportunities to do things that happen in America. Whew, now that I got that off my system, let me go on with a statement here. Because of this rule, many Americans will soon realize that they have fewer job prospects, less flexibility in the workplace, and fewer opportunities to climb the economic ladder. Thousands of salaried workers will be demoted to hourly status. These workers will feel as though they've taken a step back in their careers when they're forced to clock their hours and they no longer have flexible schedules to balance work and family. With this shift, workers will have fewer opportunities for on-the-job training and career advancement. Last year we heard from Eric Williams, who started his career working on the line at a fast food restaurant and then climbed the ranks to become an industry executive. He testified how the department's actions will limit the ability of hardworking men and women to achieve the same success, and that's reality. He also owns businesses now, but it started with the opportunity to expand his capabilities. Younger Americans, in particular, will be hurt. At a time when rising college costs and student debt are a national concern, the administration is pushing a rule that will make matters even worse. colleges and universities nationwide, including the University of Michigan in my home state, who testified in front of our subcommittee and said, absolutely, tuition costs will raise as a result of it. Not what these professors have stated, who have no responsibility for that, but people who have the concerns have indicated across the board that tuition will have to increase. They've warned this rule will force them to raise tuition and reduce services. This rule will make it harder for young people to pursue their education. And adding insult to injury, it will be even harder for them to begin their careers. Nonprofit organizations with tight budgets faced similar challenges. Every day in each of our districts, these organizations are making a difference in the countless lives, whether helping underprivileged youth, building good homes for low-income families, or serving the needs of individuals with disabilities. We should do everything we can to support and encourage these crucial services. But as one of our witnesses will testify today, this rule will do the exact opposite. Finally, Mr. Chairman, as is often the case with the administration, this rule creates new hurdles for startups and small businesses. Many won't be able to afford this mandate, even if they wanted to. Some will have no choice but to hold back on hiring, lay off workers, or cut back hours. To make matters worse, they'll continue to confront a confusing regulatory maze that encourages costly litigation. The bottom line is that this rule hurts the very individuals the administration claims it will help. That's why I introduced legislation earlier this year, along with Senator Tim Scott, to protect workers, students, nonprofits, and small businesses from the rule's harmful consequences. Today's hearing is the next step in our efforts. I look forward to our discussion and yield back to the chairman.
Gentleman yields back. I'm going to be recognizing the ranking member Scott for his opening comments, and by agreement, he will yield part of his time to the ranking member on the subcommittee, Ms. Wilson. I recognize Mr. Scott.
Thank you, Mr. Chairman. Mr. Chairman, last month the Department of Labor took a long overdue step towards addressing income inequality by restoring and strengthening overtime protections for millions of Americans. For far too long, we've let the bedrock worker protections wither, leaving millions of Americans working harder than ever with very low pay. Some of those changes over the years include, in 1965, CEOs earned 20 times the pay of the typical worker. Now they earn over 300 times. In the 1970s, the federal minimum wage was equal to 50% of the average hourly worker's pay. Today, minimum wage is only about 35% of the average hourly worker's pay. In 1975, the overtime threshold below which most salaried workers are automatically eligible for overtime pay, 60% of them were covered. Today, it's only 7%. Overtime protections in the Fair Labor Standards Act of 1938 were intended to curb overwork and help create jobs by encouraging employers to hire more workers rather than overworking the few. But the overtime salary threshold has been allowed to erode so badly that today a worker earning less than the poverty threshold for a family of 4 still makes too much to be automatically eligible for overtime pay. Congress intended that the Fair Labor Standards Act would protect and expand the middle class. For too long, the overtime regulations were consistent. And for a long time, the overtime regulations were consistent with that goal. Between 1938 and 1975, the salary threshold was updated 7 times, and it was set at a meaningful level initially and kept pace with changing economies. But over the past 40 years, the threshold has only been updated once in 2004, and that increase was far below the historical average. The Department of Labor's job is to implement laws passed by Congress. With this rule, the department has done its job, making the Fair Labor Standards Act's overtime protections meaningful again. The rule restores the 40-hour work week by raising the salary threshold to $913 a week for approximately a little over $47,000 a year. This update will make 4.2 million workers newly eligible for overtime and strengthen overtime protections for 8.9 million more workers. Today, too many workers are deemed, quote, salaried and then work 50, 60, or even 70 hours a week, working the last 10, 20, or 30 hours for no pay at all. Now, that's right. After they've worked the first 40 hours, the additional 10, 20, or 30 hours, as it's been said, they have the freedom to work those 10, 20, or 30 hours. Well, I agree. Unfortunately, with the interpretation is different because the 10, 20, or 30 hours extra are worked for free. And I'm not sure that's the freedom that most workers want. Some of these workers wind up earning below the minimum wage when all of their work hours are taken into account, and that's wrong. When you work extra, you should be paid extra. Instead of forcing workers to put in extra hours with no pay, the rule will result in some employees getting back some precious time with their families, which we know is critical to parents' ability to help children thrive. It will also create jobs by putting incentives in place for employers to spread work hours to new employees, and it will result in part-time employees having the opportunity to work additional hours that many want and need. Critically, the rule ensures that we will not see eligibility for overtime erode so badly again by requiring automatic updates for the salary threshold every 3 years. Polls show that 79% of Americans agree that it's time for our nation's overtime rules to be updated, and committee Democrats stand with our fellow Americans in welcoming that increase. I look forward to hearing from the witnesses about this rule so we can reduce income inequality and strengthen the middle class, and I commend the Department of Labor for its excellent work on this issue. And I now yield to the ranking member of the subcommittee, Ms. Wilson.
Thank you, Ranking Member Scott. The Department of Labor's final overtime rule will extend overtime protections to 4.2 million Americans, including 330,870 workers in my home state of Florida and 101,463 workers in my colleague's state of Florida. In addition to extending overtime eligibility to millions, this update strengthens overtime protections for 8.9 million workers who are already eligible for but are unfairly denied overtime pay. Salaried workers are entitled to premium overtime unless they both earn above the salary threshold and meet a duties test. Unfortunately, too many employers fail to perform a duties test, focusing only on the salary threshold, which since 2004 is near poverty wages. This focus on salary level alone has left far too many employees misclassified as exempt, depriving them of the overtime pay they deserve. Since its inception, the salary level test was designed to prevent this misclassification by screening out workers who were obviously not exempt because they failed the jobs duties test. But as the salary threshold becomes outdated, misclassification becomes more abundant as more workers are subject to the duties test. The previous salary level only screened out 15% of workers who failed the duties test. The new rule restores the efficacy of the salary threshold, simplifies application, and prevents misclassification by making clear the 8.9 million Americans who were previously subject to but failed the duties test are still eligible for overtime pay simply by virtue of their salaries. I urge my colleagues in the majority to rethink their stance on this sensible effort to prevent misclassification. I urge them also to co-sponsor my bill, the Payroll Fraud Prevention Act, which would prevent another form of misclassification, the misclassification of employees as independent contractors, which deprives them of vital wage and hour protections. I urge the majority to reconsider its position on both of these policies designed to protect workers from the misclassification that can deny them their hard-earned pay. I yield back.
Gentlelady yields back. Pursuant to Committee Rule 7C, all members will be permitted to submit written statements to be included in the permanent hearing record, and without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous material referenced during the hearing to be submitted for the official hearing record. We will now turn to the introductions of our distinguished witnesses. Ms. Tina Sharby is the Chief Human Resources Officer with Easter Seals in New Hampshire, Inc., of Easter Seals, New Hampshire, Inc., in Manchester, there's too many New Hampshires here, New Hampshire. Additionally, she is currently president of the Manchester Area Human Resources Association Board of Directors and a board member of the New Hampshire Human Resources State Council. Dr. Jared Bernstein is a senior fellow with the Center on Budget and Policy Priorities here in Washington, D.C. Dr. Bernstein previously served as chief economist and economic advisor to Vice President Biden and was a member of President Obama's economic team. Between 1995 and 1996, Dr. Bernstein held the post of Deputy Chief Economist at the U.S. Department of Labor. General Michael Rounds is the Associate Vice Provost of Human Resource Management at the University of Kansas in Lawrence, Kansas, where he oversees human resource services for more than 10,000 faculty, staff, and student employees on the KU, Lawrence, and Edwards campuses. Before joining the University of Kansas, Mr. Rounds, General Rounds, served as Deputy Superintendent in the Office of District Support for the Louisiana Department of Education. He retired from the Army in 2009 at the rank of Brigadier General. Mr. Alexander Pasantino is a partner with Seyfarth Shaw LLP here in Washington, D.C., and leads the D.C. office's Wage and Hour Litigation Practice Group, focusing in part on FLSA compliance issues. Prior to joining Seyfarth Shaw, Mr. Pasantino served as Deputy and Acting Administrator of the U.S. Department of Labor's Wage and Hour Division from 2006 to 2009. I'd like to ask our witnesses to please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect. The witnesses answered in the affirmative. Before I recognize each of you to provide your testimony, just a brief reminder of our lighting system. We allow 5 minutes for each witness to provide testimony. When you begin, the light will turn green. When 1 minute is left, the light will turn yellow. At the 5-minute mark, the light will turn red, and I would ask you to try to wrap up your testimony quickly. I'm very loath to gavel down a witness in their testimony, but we've got a lot of members here who want to be engaged in the discussion. And when we get to members, I'll remind my colleagues that you will have 5 minutes. That is for the question and answer, folks. And I'm not loath to gavel down my colleagues. We are ready to start, and I would recognize Ms. Sharby for 5 minutes.
Good morning, Chairman Klein and Ranking Member Scott. I'm Tina Sharby, the Chief Human Resources Officer for Easter Seals, New Hampshire, and I'm appearing before you today on behalf of the Society for Human Resource Management. I appreciate the opportunity to share a little bit about what this new overtime rule means for not-for-profits like mine, as well as SHRM's reaction to the final regulation. In short, Mr. Chairman, while SHRM supports an update to the salary threshold, the final overtime rule is too much, too fast. The rule will have a far-reaching negative impact on Easter Seals, New Hampshire, on our dedicated employees, and most importantly, on some of the most vulnerable members of our community. Despite overwhelming input from members of the regulated community through the rulemaking process, the administration unfortunately missed a real opportunity to put forth a rule that works for employers and employees. Not-for-profit organizations in particular will be disproportionately impacted by the rule's dramatic 100% increase to the salary threshold. And this threshold only escalates since the final rule indicates an automatic increase every 3 years. Let me briefly explain my organization. Easter Seals New Hampshire is the parent organization to Easter Seals Rhode Island, Easter Seals Maine, and Vermont. In 2015 alone, we assisted over 16,000 individuals and provided over $6 million in free and subsidized services. As a not-for-profit with limited flexibility in the budget, I have serious concerns on how I will be able to cover potential overtime expenses. Most of Easter Seals New Hampshire's funding comes through Medicare, Medicaid, and other state and federal funding sources, and funding to these programs are not expected to receive any increases anytime soon. We are unable to raise prices on products or services to clients to cover these added overtime costs. Faced with a doubling of the salary threshold, we will have no other option but to drastically reduce the services in order to continue to operate. A program at significant risk is the Military and Veterans Service Care Coordination Program, which provides services 24/7 for our veterans in emergency situations. Since the program's inception, we have responded to over 100 incidents, significantly reducing the risk of suicide. Because of the potential cost for overtime under the final rules, Easter Seals, New Hampshire will be forced to limit our ability to provide this around-the-clock care and lessen these life-saving support services. Mr. Chairman, we estimate that the final overtime rule will cost Easter Seals $427,000 in the first year alone, but the consequences of the rule are not just financial. They also impact our employees negatively. Consider our care coordinators, who are salaried professional employees. They respond to care needs whenever a service member or veteran needs help. These employees make an average of $43,000 a year. This is below the rule's new salary threshold, but clearly they conduct exempt tasks such as supervising services and overseeing the planning of client care. If these care coordinators are reclassified as non-exempt, not only will they no longer be able to provide these critically needed services around the clock, we will view their reclassification as a demotion. In fact, we've calculated that a total of 280 employees will need to be reclassified from salary to non-exempt status. Additionally, during times of crisis, these coordinators often work well over 40 hours a week to provide emergency client care. When the schedule returns to normal, they will take time off to attend other life events. Now, with these employees being reclassified, they will be forced to closely track every minute in a work week, and less likely will they be going to doctor's appointments and child soccer games. Mr. Chairman, the final rule was clearly a missed opportunity to update overtime regulations in a way that works for both employers and employees. Throughout the rulemaking process, SHRM has supported a measured increase in the salary threshold. However, doubling the salary threshold in the 40th percentile of weekly earnings presents significant challenges for employers like mine. Tying the increase to the 40th percentile sharply contrasts with historical updates to the salary threshold that represented a more reasonable increase and acknowledged differences across sectors and in certain areas with lower cost of living. SHRM and its members are equally concerned about the automatic threshold increase. In closing, Easter Seals, other not-for-profits, SHRM, and employers across the country have serious concerns with the final overtime rule. That's why SHRM strongly supports the Protecting Workplace Advancement and Opportunity Act. The bill would nullify the final overtime rule in order to have the Department of Labor do a better economic impact analysis before issuing new changes to overtime regulation. SHRM and its members look forward to working with the Congress to improve the overtime rule in a way that works for both employers and employees. Thank you, and I welcome your comments.
Dr. Bernstein, you're recognized for 5 minutes.
Chairman Klein, Ranking Member Scott, thank you for the opportunity to testify in this extremely welcome update to an essential labor standard. My first point is that in our age of high levels of income and wealth inequality, it's essential that labor standards, first established 75 years ago in the Fair Labor Standards Act, are updated. By adjusting the overtime salary threshold, this new rule does exactly that. Second, the blue line in the figure you see there shows that this adjustment, while welcomed and significant, is but a partial adjustment, one that reflects the Department of Labor's responsiveness to thousands of comments from stakeholders. Were we to fully adjust the threshold for the value it's lost since 1975, it would be set at well over $1,000 per week instead of about $900 per week, which is the 40th percentile of the lowest wage region, the South. The new threshold will also cover 35% of full-time salaried workers, a large increase from the 7% covered today, but a far cry from the 60% covered in 1975, as Ranking Member Scott pointed out. In other words, this new threshold is a reasonable but conservative choice. The U.S. economy is twice as productive as it was 40 years ago, and the workforce is much more highly educated. I know of no plausible economic reason why our labor market cannot maintain a standard that approaches what we had back then. Third, opposition to the new rule is misguided. Given the DOL's thoughtful compromises in only partially updating this labor standard and the new rule's negligible impact on the national wage bill, many of the attacks on it amount to nothing more than knee-jerk responses from business lobbyists doing what they're paid to do, fight the rule regardless of the substantive arguments that support it. And while concerns about compliance costs and costs to nonprofits and higher educational institutions deserve a response, they too missed the mark. On compliance costs, the DOL, at the behest of employers, did not change the duties test, which is the most complex part of the overtime determination. Since firms should already be in compliance with this part of the law, no new compliance costs are invoked in this area. In fact, at a recent congressional hearing, the witness representing the National Restaurant Association conceded this point, admitting that compliance with the new rule, quote, would be an easy transition to make from a management and bookkeeping standpoint, end quote. The higher threshold actually simplifies firms' compliance burden. As more workers will be automatically covered, the need for the duties test on millions of salaried workers is now obviated. The DOL also worked hard to accommodate the concerns of nonprofit and higher educational institutions. For certain Medicaid-funded providers of services for individuals with intellectual or developmental disabilities, for example, the new rule does not take effect for 3 years, providing time for outreach, technical assistance, and budget adjustment. As another example, DOL ensured that future National Research Service Award grants from the NIH will be above the new salary threshold. It's also important to note that the FLSA contains some exemptions for teachers, including professors, adjunct instructors, certain coaches, and academic administrative personnel, as well as many graduate and undergraduate students. The DOL's new guidance even highlights that the department generally, quote, views graduate and undergraduate students who are engaged in research under a faculty member's supervision as being in an educational relationship and not an employment relationship with the school, and thus not entitled to overtime. On the whole, the rule is predicted to increase the total payroll of nonprofits and higher education institutions by far less than 0.1%. I hope members keep that in mind when we listen to some of the heated rhetoric we're hearing. Most importantly, these organizations should remember that the pay and work-family balance of their workers is no less important than the pay and work-family balance of workers at for-profit institutions. The whole point of this labor standard is to guarantee employees fair workplace conditions, a point recently amplified by a group of nonprofits in favor of the proposed rule, who wrote, quote, our own workers and the families they support also deserve fair compensation and greater economic security, end quote. As these nonprofits argue, teaching or working for the public good should not require working long, unpaid hours. While my fellow witnesses may argue otherwise, I urge you on the committee to remember that we could just as easily have found representatives from the education and nonprofit sectors who strongly support the new rule, recognizing its role in valuing and respecting their workforces. Those of us who purport to care about the public good have the responsibility to practice the values we preach. This rule gives an excellent opportunity to do just that. Thank you. And I yield back my time.
Gentleman yields back, and I thank him for it. General Rounds, you're recognized.
Good morning, Chairman Klein, Ranking Member Scott, and members of the committee. Thank you for providing me the opportunity to testify on the administration's overtime rule that will impact our students, families, and hundreds of employees at the University of Kansas. When fully implemented, the recent changes to the Fair Labor Standards Act will have a significant impact on the university. KU is a major public research university and is the flagship institution in the state of Kansas. Like many public universities across the country, the percentage of university resources that come from public funding sources has decreased significantly over the past decade. While university leaders agree that an increase to the minimum salary threshold is due, an increase of 100% at one time in 2016 is difficult to absorb without significantly impacting university services. Many employees on college campuses, including KU, are currently exempt from the overtime pay requirements. To comply with the pending increase in the exempt threshold from $23,660 to $47,476, colleges and universities may increase the salaries for a few individuals whose current pay is closest to the new threshold, but will need to reclassify the majority of impacted employees to hourly status. While in some cases these changes are appropriate and would keep with the spirit of the legislation, in many instances, KU is being forced to reclassify employees who work in jobs that have always been exempt and are well suited to exempt status. It's KU's position that this widespread reclassification is to the detriment of both our employees and students. As a nonprofit and public entity, KU is reflective of the higher education industry and our inability to absorb the increased costs that come with higher salaries for exempt employees, expanded overtime payments, and other labor and administrative costs associated with transitioning traditionally exempt employees into non-exempt status. In the face of these costs and challenges, KU will ultimately be forced to adjust or reduce services, eliminate or consolidate positions, or at some point raise tuition, all to the detriment of our students. The changes will also increase the cost of and thus inhibit important research done by the university. Unfortunately, due to recent cuts in public funding, the university does not have the central funding flexibility to apply against the financial impacts of the adjusted overtime rule as we enter a new state fiscal year on 1 July. With no central fiscal flexibility, KU is compelled to pass any financial responsibilities for addressing the legislation along to our schools, department, and research centers. Working on relatively fixed budgets, each unit has limited options available to address the mandated changes. In the short term, the primary impact will be felt in the reduction of services or the elimination of positions. Ultimately, our most important stakeholders, students, will bear the burden of these adjustments. As of June 6, 2016, the university has 354 currently exempt employees impacted by the revised overtime rule. The projected cost to raise these employees to the new annual salary threshold is around $3 million. The alternative, if chosen, is to switch these employees to a non-exempt status and pay them overtime. The projected overtime cost to sustain our current level of services is roughly equivalent to the cost to raise each employee to the new exempt threshold. Since neither of these options are currently financially feasible for any of KU's units, it is inevitable that there will be a reduction in the services currently being provided by KU units to students as we transition employees from their current exempt to non-exempt status without the flexibility of working more than 40 hours per week, regardless of mission demands. The one relatively flexible financial lever that the university has to increase revenue is to raise tuition. Tuition increases need to be approved by the Kansas Board of Regents and are justifiably closely scrutinized. For the upcoming fiscal year, beginning in July, the window to use a tuition increase to help mitigate the impact of the new overtime rule in 2016 and 2017 has closed. It is probable, however, that tuition will ultimately be pushed higher in future years in order to address the enduring impacts of the new overtime rule. Due to both the near and long-term fiscal impacts of the new overtime rule, KU believes that the Protecting Workplace Advancement and Opportunity Act is important legislation because it would require a more detailed economic analysis, including understanding and mitigating the impacts on higher education, before these dramatic changes to federal overtime pay requirements are fully implemented. In conclusion, Mr. Chairman, at KU we appreciate the administration's ambitious agenda to promote affordable, high-quality educational opportunities, expanding access to college, and providing the support necessary to drive students to on-time completion and long-term success. However, the new changes to the overtime rule represents a major expense for public university and puts our campus in further financial strain as we continue to deal with decreased state funding. There is simply no way for universities like KU to absorb costs of this magnitude without an impact on our academic research and outreach missions that will be felt by the public and students we serve. Thank you.
Thank you, Mr. Passantino. You're recognized.
Thank you. Chairman Klein, Ranking Member Scott, members of the committee, thank you for the opportunity to speak with you today regarding the Department of Labor's revisions to the white-collar overtime regs. As a partner in the Washington, D.C. office of Seyfarth Shaw, my practice focuses on helping employers comply with the FLSA. I spend my days providing advice and counsel to employers on things like independent contractor status, overtime exemptions, and other pay practices. Since the department announced its revised regulations 3 weeks ago, I've been discussing this issue pretty much nonstop. With employers, with trade associations, with colleagues, and I'm pretty sure that my family has been subjected to it as well. Today, though, I want to focus and spend the time flagging some of the compliance challenges that employers will face in the coming months as they decide how to proceed with the revised regulations. Certainly, a few employers, particularly in some industries and in some higher wage regions of the country, may find that all they need to do is decide and flip some switch. For the vast majority of employers, however, the revisions require a thorough analysis of the costs and benefits associated with each of the several options for currently exempt employees earning an annual salary between $23,000 and $47,000. On the one side, you have the increased costs of the increased salaries, not just for the affected employees, but for supervisors or for more experienced employees to avoid salary compression. On the other hand, we have the impacts of converting employees to non-exempt status. And as explained in more detail in my written testimony, those impacts include harming the ability of employers to provide and employees to take advantage of flexible scheduling options, including part-time employment, treating employees in the same job classification for the same employer differently based on regional cost of living differences, limiting career advancement opportunities, decreasing morale for those employees who are demoted to non-exempt status, particularly where peers in other locations remain exempt, reducing employee access to a variety of additional benefits, including incentive pay, deterring employers from providing newly reclassified employees with mobile devices and remote electronic access, further limiting employee flexibility, increasing FLSA litigation based on off-the-clock and regular rate of pay claims, and introducing a host of other legal and operational issues such as increased costs for administration. It's important to remember that converting an employee to non-exempt status means that the employer must treat the employee as non-exempt for all purposes. This means accurately tracking time, ensuring compliance with the minimum wage and overtime provisions, and properly computing the regular rate of pay for overtime. With respect to tracking time, converting employees to non-exempt status means throwing them into a regulatory scheme developed for the workplace of a different century. It would take them from the 2004 white-collar exemption regulations and place them under regulations where the cases cited are from the 1940s and the 1950s, although in fairness, there's at least one case from 1960 cited in those regulations. It uses as examples people who are working crossword puzzles and playing checkers while they're waiting around on the job, telephone operators who have switchboards in their homes. In the modern workplace, the old understandings of waiting time, travel time, work time, and even workplace are pushed beyond the point of breaking. When you're talking about email, working on a laptop from a coffee shop, taking a call in the school pickup line, and all the time in between, whether it's travel or waiting, the current rules don't work. How does an employer determine what time is paid and what time is not? Where do the principles of continuous workday begin and end? The answers aren't clear. The regulations, guidance, and cases provide arguments on virtually every side of the issue. And every day, employers are sued over the seemingly minor bits of time that have not been included in employees' hours of work. Yet, it's the employer's obligation to keep adequate records of the employee's time, not just an 8 written at the end of the day, every day, but the actual hours worked. And failure to do so results in severe consequences to employers in litigation. Under the existing rules, payments like bonus payments, incentive payments have to be included in a non-exempt employee's regular rate of pay. Sometimes that has to go back over the course of a year. Faced with that difficult calculation, employers often forego those types of incentive payments to non-exempt employees. The issues that I'm raising now don't include issues related to morale, the get-it-done mentality, part-time employment, and even how employers are going to pay. So once the employers decide they're going to convert someone to non-exempt status, they need to determine how they're going to pay, the rate they're going to pay, whether it's going to be a salary plus overtime, whether it's going to be straight hourly. Once those decisions are made, employers have to communicate. They have to craft communications to explain this to employees, and they need to do it in such a way that has the employee understanding that they're still a valued member of the team and that they're not diminished in any way because they're losing their exempt status. And employers also need to craft these communications because the plaintiff's lawyers have already announced that they're on the lookout for new cases based on the reclassification. On top of that, this process will repeat itself every 3 years as the department increases the salary automatically every 3 years. In exchange for this, the department's revisions do little to promote the president's directive to modernize the regulations. Rather, they're going to place large numbers of employees under a regulatory scheme that was last updated in the 60s and is fraught with uncertainty. The department itself is going to issue a request for information on some of these issues related to how the regulatory framework applies to the modern workplace. Unfortunately, employers don't have the luxury of waiting for the department to modernize the regulatory scheme. They need to be in compliance by December 1st, and the clock is ticking. Thank you for the opportunity to appear before the committee, and I look forward to your questions.
Thank you, sir. I thank all the witnesses. Let me start questioning with you, Mr. Passantino, because you kind of want to roll here. You know from your time at Wage and Hour that it is time-consuming to create regulations in accordance with the Administrative Procedure Act and governing law. But the reason Congress established this process is because it's so important to offer the public, including affected stakeholders, the opportunity to provide commentary informing the rulemaking process. Your testimony correctly notes that the Department's regulation sets a process automatically increasing the salary threshold every 3 years without fulfilling all of the procedural requirements designed to produce good rules. Can you take a couple of minutes here and explain how dangerous that is and possibly illegal that is to establish this process?
Sure. By eliminating the notice and comment rulemaking process for all future salary increases, the department has apparently decided that it doesn't need the input of the regulated community. So historically, it's been notice and comment. The department proposes a salary level. The regulated community weighs in, says we think it's too high, we think it's too low, and they take those comments under consideration, and those comments and then the final rule comes out with a new salary level. In 2004, the salary level proposed was lower than the salary level in the final rule. In 2016, the salary level proposed was higher than what happened in the final rule. So it can fluctuate in both directions depending on what the comments say. What the department has done is said, we don't need to hear from the regulated community. We don't need to understand what the economic conditions are and how this is going to impact anyone who is directly affected by this rule. We're just going to update this every 3 years based on a standard that we've identified now in 2016, and we're going to do this for eternity. I don't believe that complies with the Administrative Procedure Act. I think it is sort of a super proposal for eternity. It's just, we're going to propose this standard for all time. Congress has never authorized automatic increases, and I think it is highly problematic that the department is doing that.
Thank you, sir. I yield back and will recognize Mr. Scott.
Thank you, Mr. Chairman. Ms. Sharby, did you indicate that $265,000 will be the cost to raise all the salaries up to the exempt level?
Yes, that's correct.
So that anybody making from about $23,000 could get a raise to over $23,000. Everybody between 23 and 47 could get to 47, and it would cost you $265,000.
Correct.
And you would be right back. You'd be where you are today in terms of dealing with the overtime rule. What is your total budget?
We're very close to 100 million.
1% of 100 million is 1 million. And you're talking about 265,000?
That's just in the cost to raise the employees to the new salary threshold. That doesn't take into consideration.
Which would put you right back where you are today.
Doesn't take into consideration the overtime cost. That will definitely dramatically increase.
No, there'd be no overtime because they'd be exempt. Those employees would be in the same situation that they are today in terms of overtime.
Excuse me, when I gave that number, that's not to bring all of our employees up to the new exemption. Those are the employees that we feel that we have to bring to the new exemption, given their level of responsibility. Very many of our employees would not be going up to the new salary threshold.
What kind of hours are these employees working today?
It depends on the position.
After they work 40 hours and they're now considered exempt over 23,000, what is their hourly rate of pay after the 40 hours today?
I couldn't answer that.
It's zero. Isn't that right, Dr. Bernstein?
Yeah, that's right. I mean, these workers are not being paid overtime, so any hour worked after 40 hours under current conditions, before the new rule goes into effect, is paid zero.
Not time and a half, not straight time?
No, it's just, these workers are paid for 40 hours. Any overtime they're working is not covered. These are workers who are deemed exempt by dint of their salaries or their duties, and therefore they're not paid for overtime, so any hour of overtime worked is paid zero.
And so if you have a full-time employee who's already worked 40 hours and a part-time hourly worker who's worked 20 hours, and you got to get 10 more hours of work done, if you lay it on the 40-hour full-time worker, how much does it cost you?
Well, it costs you...
If they're exempt.
It costs you, I mean, under the new rule, it will cost you time and a half, and I think
And under the present law, what would it
cost you zero under the present law.
And if you did it to the part-time worker, you'd actually have to pay for the 10 hours.
Well, that's right. But I think one of the points, if I may, Ranking Member Scott, one of the points you're getting at here is something that I think is very important for my colleagues to, on the witness stand to consider, because I don't think they have by dint of their testimony, which is that there are various other ways that the increased threshold can be absorbed other than taking people up to the salary, up to the top salary cap. My colleague from the University of Kansas suggested that everyone will have to be taken up to the salary cap. But of course, as you just pointed out, you can take workers who are working part-time, increase their hours, as long as they remain below 40, there's no change to payroll. There's no change to payroll based on the overtime change. In other words, they're under 40, so they're not getting time and a half. They would be working more hours, and they'd have to be paid more straight time. There are various other absorption mechanisms. You can create more jobs at straight time. That's another way to avoid the overtime threshold, and I actually think that's a very positive development. Various analyses, including, by the way, the National Retail Federation, which testified here, suggested that the new rule would create over 100,000 jobs through this mechanism. Employers avoid paying the new overtime by creating straight-time employment.
Thank you. Mr. Rounds, did you say in your testimony that you could you could raise everybody from the under 47 that's making more than 23 up to 47 to get them back to exempt for about $3 million?
Yes, Ranking Member Scott, that's, we have 354 members as of today who are under the new threshold.
Right, and you can get them to 47.
And that costs us about $3 million.
About $3 million. What's your total budget?
I don't have the university's...
Over a billion?
It's over $1 billion.
1% of $1 billion is about 10 million?
Yes.
What does your basketball coach make?
The basketball coach, Mr. Bill Self, is not a state employee, and therefore I don't have his salary.
And the gentleman's time has expired. Mr. Wilson.
Thank you, Mr. Chairman, and thank each of you for being here today. Ms. Sharby, I really appreciate your service. Easter Seals makes a difference around our country for so many people, so thank you for what you do. I'm also very grateful that I have 4 sons who have participated in the Boy Scouts of America. And with the extraordinary encouragement of my wife, all 4 of them are Eagle Scouts. During a recent discussion with the Indian Wars Council Scout executives, I was informed by the negative impact of the regulation will have on the Boy Scouts in South Carolina, which makes such an important difference in the lives of the young people of our state. Can you expand on the impact this regulation will have on the quality and quantity of services that nonprofit organizations will be able to provide families?
Yes, I can. Currently, Easter Seals relies on level funding at best. Usually, we are forcing cuts in our budget. And we're going to have to consider how we are going to be able to continue to provide these services. As I mentioned earlier, we provide free and subsidized services. So that's going to be an area where we're going to have to pay particular attention to due to the lack of funding. In addition, it takes a long time to develop a relationship between the staff member and the person who's receiving services. It's not as simple as saying, okay, now we'll hire a new staff member to come in and pick up the responsibilities. In the state of New Hampshire, with a 2.6% unemployment rate, bring them on. I have 150 staff vacancies. If you have people that you can send to me that are qualified to work for Easter Seals, I'd be happy to interview them, but that's simply not the case. So our employees come to work for us because they believe in the mission. They don't necessarily come for the salary. They want to be paid a fair salary. I totally support that. But they come for the mission to make a difference in the lives of the individuals that they serve. And now we're creating a situation where they're not going to have the flexibility to do the things that they feel are necessary in order to provide this quality care.
And indeed, you and your staff are making a difference. General Rounds, over the past several months, I've had the opportunity to speak with many colleges and universities throughout the state of South Carolina regarding the impact of the Department of Labor's overtime rule. At South Carolina's flagship university, the University of South Carolina, this rule will affect nearly 1,000 employees, cost the university over $1 million a year to comply, which I believe could lead to destroying jobs. In a time when universities are facing a decrease in state funding and students are facing rising tuition costs, can you speak on the ultimate impact this burdensome and expensive overtime regulation will have on faculty, students, and programs?
Thank you, Congressman Wilson. As you mentioned, it does have an impact on our ability to provide the same type of response for many of the employees who are impacted. As you know, universities are not 9-to-5 organizations. They're cultures that are responsive to our primary stakeholders, which are students. And many of the employees who are affected by this are employees who are directly engaged with students on a regular basis. And if we try and force them into a 9-to-5 box, it will make it very difficult for them to provide the same services and maintain the same culture that we currently have at KU.
And I've seen it personally. I have a dear neighbor who is a tennis coach, and she sees this as catastrophic to her ability to work with the students at the college that she teaches. Mr. Passantino, there was recently an article in the Los Angeles Times where the millennial generation is the most likely generation that would like to change careers, give up promotion opportunities, move the family to another place for flexibility. What kind of impact will this have on businesses that do provide flexible alternatives for persons who use laptops and smartphones?
I think the most significant piece is for those employees who are reclassified as non-exempt, so who are below the threshold and the employer decides not to bring them up to the new threshold. It's going to be difficult for employers to continue to provide them with those opportunities. Whether particular time is compensable, paid under the Act, depends on a lot of facts and circumstances, but there are principles that have been in place for a very long time that simply don't apply when you have someone who starts in the office, goes to a coffee shop, heads off to a softball game, works at home. They don't apply in the same way as they do in the more traditional workplace.
Thank you very much.
Speaking of basketball, Mr. Courtney, you're recognized.
Thank you, Mr. Chairman, and thank you to the witnesses for being here today. Again, I think I want to follow up on a point Mr. Scott was making in terms of trying to, step back and look at this from sort of a, total global standpoint in terms of the impact of this rule. Dr. Bernstein, on page 5 of your testimony, you mentioned what the actual impact on the nation's wage bill is going to be. And again, I don't know if you have it at your fingertips, but I'll let you, underscore that point.
Thank you, because I think it's really critically important to scale some of the numbers we're hearing by, just as Representative Scott was suggesting, by the budgets of the organizations. And when you do so, you find that nationally, the costs of the new rule will amount to less than 0.1% of national payroll. Now, national payroll is in the trillions. So we're talking about a relatively small group of workers who are newly covered, and among that group of workers that are newly covered, those who are more likely to work overtime. Now, in the higher educational sector, that payroll share also amounts to well under 0.1%, and in the nonprofit sector, again, less than 0.1%. And in fact, if you look at the affected workers who usually work overtime in both the higher ed sector and the nonprofit sector, it's less than 1% of their workforce. Now, I still think this is an important rule, and not all the benefits are monetized. Some of the benefits come from being able to balance work and family. Tremendously important, but it doesn't show up in the national accounts as extra dollars. But when you go on the monetary side, you see the fractions involved here, I would say, very much belie the level of some of the rhetoric we're hearing.
Thank you. And I, again, also think that the narrative that somehow the Department of Labor stonewalled any input that came in during the rulemaking process. Again, I also served with Mr. Wahlberg on the Workforce Protection Subcommittee when Fair Labor Standards was discussed, and indeed I would agree with the chairman's comments that it was in need of an update and a modernization. Again, I kind of came to a different ending point in terms of what needs to be updated, and that your graph certainly showed that, how this rule had just deteriorated to the point that it was less than 10% of the American workforce that was getting any benefit from it. And again, during the rulemaking process, nonprofits were listened to. Again, as you pointed out, the Medicaid waiver programs for people with intellectual disabilities, again, they operate under a one revenue system of operation, and it's very rigid because these Medicaid waivers are under caps. And again, the department gave a 3-year non-enforcement accommodation to those programs. In terms of universities and research, as your testimony points out, the National Institute of Health, in terms of future research grants, is going to, again, align these grants to comply with the rules. Is that correct?
Yes, by aligning the grants to comply with the rules, what you're saying is that the grants will equal the upper bound of the salary threshold and thus not invoke higher overtime costs. And I think it's really germane, and I have a great deal of respect for my colleagues on the panel who are providing important services, as was recently mentioned. I think it's germane that both of them, and I very much underscore their point, have pointed out that their problem is less with this overtime rule and more with their funding streams. And I think in the case of Kansas, that's particularly striking because in Kansas, we know there's been this experiment with tax cuts, and these cuts taking effect in 2013 have blown a $400 million hole in the state budget. State spending on higher education per student in Kansas is down 22% since 2008, and my colleague Mr. Rounds made those points very, very clearly. But what you can't do in my mind in terms of a labor standards is cut taxes on wealthy people so that you cannot pay middle-class people a fair wage for a fair day's work.
And having talked to Secretary Perez, I think this question of the Medicaid waiver programs, I mean, frankly, the Department of Health and Human Services has to be brought into this discussion in terms of how they set these waivers so that, again, it will align with these new fair labor standards. So, again, I think you're right that this is going to create a healthy sort of discussion both at the state level and the federal level about trying to get, whether it's research grants that affect UConn or KU, or whether it affects nonprofit programs that provide critical services for vulnerable populations, that they get the adequate resources to create a living wage. I yield back, Mr. Chairman.
Gentleman yields back. Dr. Rowe.
Thank you, Mr. Chairman. General Rounds, thank you for your service to our great country and all the panelists for being here. I was asked to speak about 2 weeks ago at the Tennessee Valley Carter meeting on entrepreneurship and job creation. And I wondered why, when you hear the administration say that we have 14.5 million new jobs, unemployment rate has gone down from 9% to 5%, all are true. Why is it when you poll the American people that 70% and a majority of Democrats are saying the country's headed in the wrong direction? It doesn't make sense. I mean, those two things together don't make sense. And I began to look at it in detail. And what's happened is between 1992 and 96, during that recession, 420,000 new businesses were formed in this country. Between 2002 and 2006, 400,000 new businesses were formed. Between 2010 and 2014, 166,000 businesses were formed. And what happened was 20 counties in this country made up half the new businesses formed in America. And 60% of the counties in America actually had a net loss. That's why we as the American people feel like we're going in the wrong direction. And in my opinion, the way the other side, Dr. Bernstein, you are an advisor to the president, believe that raising the minimum wage and doing this salary is actually helping the economy. It's not. If complying with government regulations were a country, it would be the 4th largest country in the world, just compliance cost. And this is going to add another compliance cost to what we're doing. I'm a Boy Scout, an Eagle Scout. I worked at a scout camp every summer. There's no way on this earth that non-for-profit, as a matter of fact, I've got to write them a check when I get home. There's no way in the world that they can comply with this. If you're a scout leader and you go by on a Friday morning to set up a jamboree for the weekend for Boy Scouts, by Sunday morning you got to leave them because you've done your 40 hours and you haven't worked all week. I worked there 24 hours a day, 7 days a week when I was a camp counselor. As you were saying, when do we start counting? You talk about 0.1% at the University of Tennessee. It's going to add $9 million to the University of Tennessee system, which is a 2% increase in tuition for every student in the system. I talked to one of the land-grant colleges 2 weeks ago when I was at the Valley Corridor meeting. It's going to add $2 million cost to that one college. Tuition costs have skyrocketed. That's the last thing we need to do. And at the University of Kansas, that cost has got to be passed on. And Dr. Bernstein, I'll point out, in our great state of Tennessee, we have cut taxes. We have the lowest per capita debt in the nation. We provide free community college for people, so it can be done by lowering bureaucratic hurdles, and this is just one of them. General Rounds, I want you to, because this to me is a very personal. I was on the foundation board of my college, and providing a quality education for someone like me who's a first-generation student, it's another barrier that's out there. And I don't know how non-for-profits, like Ms. Sharby, you're talking about, are ever going to comply with this. So, General Rounds, if you'd like to comment on the cost, and then Ms. Sharby, if you would.
Thanks, Congressman Rowe. As I pointed out in my testimony, if you look at the fact that we're relatively flat or decreasing in our budget, it makes the absorption of any additional cost very difficult without taking dramatic steps. And in this case, the ability to absorb these costs because they're not available means that for the majority of the individuals impacted, they will become non-exempt as opposed to exempt, and they will not be able to provide the same services that they currently do because they have very good flexibility in how they execute their job responsibilities. They will lose that flexibility.
Well, my good friend, the ranking member, brought up the basketball coach at the University of Kansas. Well, that's fine, but what about these small state schools where I went, where a coach may make $35,000 or $40,000 a year, and they're out recruiting athletes? How in the world do you ever? They're driving 8 hours to a game. How in the world are you going to comply with that? I have no earthly idea. Not everybody is at the University of Kansas at a major university. Trust me. When you're a coach at Austin Peay State University, where I went, you're making small, little teeny bucks, not the mega bucks that a great coach like that he is making. So my time is about expired. I do want to, Mr. Chairman, I want to submit this new map of economic growth and recovery as a matter of the record.
Without objection. And the gentleman's time has expired. Ms. Fudge, you're recognized.
Thank you very much, Mr. Chairman. Thank you all for your testimony today. Mr. Bernstein, in your testimony, you note that the FLSA overtime exemptions were designed and intended to cover a particular class of worker. These exemptions have now been construed to cover assistant managers or supervisors that don't necessarily meet the duties test. How has the manipulation of this exemption, which in fact it has been manipulated, negatively and unfairly affected low-level management workers, causing them to lose out on overtime that they should receive?
By misclassifying them as exempt, thus prohibiting them from getting time and a half when they work beyond 40 hours a week. If you actually look at the intention of the FLSA and the duties of the types of workers you're mentioning, these are workers who very much should be covered by overtime protections, but are not. Therefore, and it's much like the conversation I was having with Representative Scott a minute ago, when they work an hour, 2, 5, 10 hours of overtime, every one of those hours costs $0 to their employer. There is There is...
Excuse me, sir, the time is not accurate. Please proceed.
Okay. Every one of those hours is unpaid. One of the most important aspects of the new rule is that it does away with this confusion around the duties test. By updating the salary threshold and setting it at $913 per week, these workers will now be automatically covered.
So in effect, for many, many years, they have actually benefited by the misclassification and have gained significant dollars that they really should have been paying people for a very long time.
That's correct. And in fact, we were talking a little bit a second ago about the underlying economy and some of the dynamics therein. One of the problems we've had is this increase in economic inequality. Whether it's wage or wealth or income inequality, it's doubled in terms of a share of income to the top 1% over the past 35 years. One of the things you see is that the profit share of national income recently reached historic highs. It's coming down a bit as the job market has tightened. And that's one of the dynamics that we're describing here. Workers are not being fairly compensated, and that's helped to boost profit margins. That's not a bad thing. Profit margins are good, but profit margins should afford you to be able to pay a middle-class wage to workers who are working over 40 hours a week.
And employers have unfairly benefited from it.
Correct.
Mr. Bernstein, we have repeatedly heard the argument that raising wages in any way would stifle job creation and economic growth, and today is no different. We hear the same thing. Our failure to act has seen the demise of the 40-hour work week, and that is what we have seen today, really the demise of the 40-hour work week. Could you elaborate on how this salary increase will actually help economic growth and not hurt it?
Well, a number of ways. One of the things I mentioned earlier, I think, is quite important. There are many labor economists who believe that one impact of the new rule will be the creation of new straight-time jobs. That is, employers who don't want to pay overtime to newly covered workers can avoid that by hiring other workers and paying them straight time. Also can increase the hours of their part-time workers, yet still keep them below 40. Now, Goldman Sachs argues that that would create about 100,000 jobs. National Retail Federation argues more. To the extent that workers working more than 40 hours, newly covered, are now making time and a half, these are workers who earn middle-class incomes, middle-class salaries. The top threshold in an annual sense is about $47,000 per year. That's actually below it's about around the median household income. These workers tend to spend their paychecks, so that feeds back into the economy. We have a 70% consumption economy. That's pro-growth. And in fact, you've talked about a sloggy macroeconomy. One reason for that has to do with this inequality problem and the fact that when the benefits of growth flow to the top of the scale, consumption tends to be less robust.
I have no further questions, but if there's something you want to address in my last 2 minutes that you've heard, please feel free.
You know, I think there is a real lack of care, and I'm glad Mr. Passantino is here because I sense he really understands these rules. I think there is a lack of care and consideration by many folks who oppose these rules in terms of what's actually in there. We just heard a member complaining about coaches and the need to pay overtime to coaches. Well, athletic coaches, assistant coaches who fall under the exemption that when their primary duty is teaching are exempt. And so there are a variety of exemptions, teachers, academic administration personnel, graduate and undergraduate students. I urge my colleagues on the witness stand in their institutions to look much more carefully at that aspect of the rule. I will say, since we're talking about coaches, I will note that at least it's my understanding that the basketball coach at KU, and I'm a huge Jayhawks fan, just to get that on the record, is paid something in the range of $5 to $6 million a year. Now, if Mr. Round's numbers are correct, that means that you could fully compensate for the overtime cost that he designated and still pay their basketball coach about $3 million a year, which sounds pretty good deal to me.
So we agree that the coach is exempt. The gentlelady's time has expired. Mr. Wahlberg.
Thank you, Mr. Chairman. I guess I've gained more understanding of why our economic growth at an anemic 2% or less is what it is with economic advice that's coming, like what we're hearing today. It's frustrating to think that we have an administration that thinks you can name it and claim it, and that businesses, universities, and others can simply pick the dollars out of the air to pay, and that doesn't happen. And when we get into social welfare agencies, and we get into charitable causes and entities that provide real basic help to people, this isn't reality. And that's what's frustrating. And maybe that's why we're at that level of growth. It's interesting also that with the Puerto Rican bill that's being considered right now, the administration is willing to forego overtime regs and a minimum wage for 25 and under, indicating that'll help grow the economy in Puerto Rico. Just want to bring that up. Hypocrisy that we hear. Mr. Pasatino, Department of Labor's final overtime rule is going to result in the demotion of salaried exempt employees in every corner of the country. By DOL's own estimates, very few of the department's estimated 4.2 million impacted employees will actually see any potential benefit from this rule because they do not currently work more than 40 hours per week. However, these employees will be negatively impacted when they lose workplace flexibility, opportunities to attend training and networking events, and certain performance-based bonuses as a result of being reclassified. Do you anticipate, Mr. Pasatino, significant morale issues amongst employees as a result of these changes?
I think in talking to clients since the rule's been out, I think that's a very likely probability. As is in my testimony, as I said earlier, I mean, one of the issues is with respect to mobile devices and remote access, as annoying as they may be from time to be tethered to the world, to your job all the time, it also allows you to be away from your job for parts of the day, and to be away from your workplace and to get things done when you're not sitting at your desk.
The workplace of the 21st century, right?
That's right.
Flexibility, opportunity, choice.
We've also talked to employers about the bonus issue and the fact that...
Yeah, talk about that. Talk about the bonus issue and the impact of this rule.
So for non-exempt employees, when there are non-discretionary bonuses, and non-discretionary bonuses are basically all of your incentive types of payments, those get included in the regular rate of pay for overtime purposes. So if you have someone who's making $10 an hour, their overtime rate would be $15 an hour, but if they got a bonus on top of that, you'd have to go back and recalculate their overtime rate in order to determine what their new overtime rate is.
Hurting many of the people that appreciate the compensation that comes from bonus and opportunity, expanded opportunities.
Well, frankly, I mean, we talk to employers who, when we explain everything that is necessary to recalculate that rate of pay, they just decide to forego the bonus.
No bonuses.
Right.
Yeah. Mr. Pasatino, contrary to the department's assertions, changes to expand overtime eligibility will not necessarily result in a windfall of overtime income for newly classified non-exempt employees. Will you describe some of the adjustments employers will consider making in order to keep labor costs under control?
I mean, one is that they can limit the amount of hours that someone works. Another is you can reduce the base rate of pay so that if you expect someone to work 45 hours a week, their previous salary becomes, you divide it by 45, or you divide it by 45 plus something else, and then their hourly rate will get them to what they made anyway. So they make the same, except now they're keeping track of their hours and they're getting paid for overtime. Up to that 45, and then they'd be paid time and a half over that. You can pay them on a salary that reflects their current pay, and then they would get a little bit extra for the amounts they work over 40. So there are a variety of different ways that it can be accommodated. I think the other part of the equation is it may change the way that employers hire in new individuals to those positions. They may come in at lower rates to account for that overtime premium.
Generally going back to the 20th century, when we're in the 21st and moving rapidly in this 21st century to something expanding in the workplace. Thank you. I yield back.
Gentleman yields back. Mr. Polis, you're recognized.
Thank you, Mr. Chairman. You know, stepping back for too long. Workers across our country have simply been putting in more and more hours without receiving the compensation they deserve. We've talked about many examples, but a manager at a fast food restaurant in my district might earn a salary of $26,000 a year, but work 50, 60, 70 hours. At that salary, a family of four is well below the poverty line. But under the new overtime rules, they'll finally be compensated for their work and receive the pay they deserve. In fact, my district, or my state, has 248,000 workers that will benefit from the overtime rule. I'd also like to note that this update would directly benefit 275,000 workers in my colleague Mr. Wahlberg's state, who we just heard from. And I think that's something that's long overdue and that workers deserve. There has been some discussion of higher ed workers, and I wanted to go to Mr. Bernstein. On that, I represent a district with two institutions of higher education, Colorado State University and University of Colorado at Boulder. There's been a lot of discussion about the rule's effect on higher education. And to be clear, I wanted you to talk about what actual impact might this have on higher education and what % of the higher education workforce would even be affected by these rules.
Yeah, thank you. According to numbers from the Labor Department, 3.4% of workers at colleges and universities would be affected by the rule change in the sense that their incomes are, their salaries are between the current and the new threshold. However, it then becomes important. Most workers in that bound between the old and the new threshold, most workers don't work overtime. So the next thing you have to do is ask how many of the workers in the affected range work overtime, and that gets you to 0.5% in the higher ed sector, and by the way, a 0.8% in the nonprofit sector. So less than 1% of workers affected in that regard, and as a share of their payroll, as I've been stressing throughout the discussion, under 1/10 of 1%. In both cases, whether we're talking national, higher ed, or nonprofit.
And in addition, with the particular carve-out around instructors that under the guidance from the Departments of Labor generally covers assistant athletic instructors and others. So some of those, even some of those 0.5% out of the 3.4% that make in that range that might work more than 40 hours a week, aren't some of them even in the teacher exemption categories, some of those workers?
Right. So this is, again, it is critical to go back and understand the nature of the exemptions. Bona fide teachers, coaches, graduate and undergraduate students, academic administrative personnel are often exempt, meaning that the new rule will not affect their pay. In postdoctoral cases, which is an important area for my friend here from higher ed. Again, I want to underscore that the Department of Labor has been working closely with the NIH and the National Science Foundation to ensure that grants are now at the level of the upper bound of the salary threshold.
And if there are workers that are affected, that I think you're down to whatever 0.1% or 0.4%, let's say it's a janitorial manager or something like that. You know what? The universities need to maintain a competitive pay scale with the private sector anyway. If the private sector is paying overtime and somehow the university were exempt from it, would they even be able to engage or hire somebody for these positions?
Well, I mean, if the job market is soft enough, they might, but in a tighter job market, they wouldn't. But I think, the key point here is that it's really hard to understand why someone who chooses to work in the public sector should be treated differently than someone who works in the for-profit sector when it comes to fair pay for overtime work. I think as my colleague, Ms. Sharby said, that these workers want to be paid a fair salary, and I think that's a great point. There's no reason, especially when we're talking about an impact that's less than 1/10 of 1% on payroll, that workers in one sector should be treated so unfairly relative to workers in a different sector.
Well, and even just, again, economically, if we want the nonprofit or public sector to attract talented workers, they have to have overall compensation packages that are competitive. Obviously, overtime is part of that, vacations are part of that, pay is part of that, benefits are part of that. But overall, you need to be competitive, or you're going to wind up with the least talented people in these positions, simply because the more talented ones are taken up by the private sector. So we have to be competitive across all sectors. I think consistency of rules is very important to do that, and I yield back.
The gentleman yields back. Mr. Guthrie.
Thank you very much, and I want to continue talking to Mr. Rounds on this idea of colleges, and I understand University of Colorado, University of Kentucky, KU, are large enterprises. Well, Kentucky has a lot of small colleges, that were brought into being 100 and 150 years ago for mission-oriented, and I have a written statement addressed to the committee from Dr. William Luckey. He's the president of Lindsey Wilson College in Columbia, in Adair County in Kentucky. And the statement raises very serious concerns with the overtime rule, and I will ask it to be entered into the record.
Objection.
Lindsey Wilson College is a small, private, nonprofit college serving one of the poor areas in Kentucky, and actually one of the poor areas in our country. 62% of the college undergraduates are Pell eligible. 50% of its Pell eligible have an expected family contribution of 0. Lindsey Wilson students receive more in state-based grants than any other private college in Kentucky. And I'd like to read from Dr. Luckey's statement summarizing Lindsey Wilson's college concerns with the overtime rule. It says, the DOL website states, the ruling will transfer income from employers to employees. I can tell you that in our case, and in the case of hundreds of private colleges that submitted comments to OMB, with this rule was under review, just the opposite is going to happen. Employees will lose their jobs, and many other salaried professionals will be relegated to a lower profile non-exempt status, because for nonprofits like Lindsey Wilson, there is no extra employer money to transfer. But our students, who are among the nation's most needy, will suffer most. When the changes to federal overtime rule take place at the current amount and in the current time frame of implementation, it will be devastating to Lindsey Wilson College, and I dare say it will hurt, not help, small colleges all across America. So Mr. Rounds, that's the end of the quote from that. Mr. Rounds, many small private colleges face strict budget constraints. 95% of Lindsey Wilson's revenues come from student enrollment. When costs go up, tuition must rise or services must be cut. In this regard, is Lindsey Wilson's predicament similar to KU's as it faces the overtime rule?
Thank you for the question. It is similar to KU's. And what I would like to point out is with the 354 individuals who are currently considered exempt, 92 of those are postdocs, and as I had put into my testimony, we plan on bringing them up to the new threshold, because to not to do so would make us non-competitive. Obviously, that has a huge impact on us because there's a fixed budget. Granted, NIH is going to raise future grant levels. We're working under current grant levels, and so under a fixed budget, But
Lindsey Wilson is not a grant-based institute. You know, it doesn't do a lot of it's 95% student tuition, not NIH research. But so I know it's a separate. Maybe it's a little different from University of Colorado. But please continue.
Yes, sir, but the remainder of the individuals are not in that position where they're tied to grants, and we can do the adjustment in order to bring their salary levels up. And so in those cases, we're going to have to make them non-exempt employees. And as we make them non-exempt employees, has been pointed out on several occasions, is that they will lose their workplace flexibility. I think the portrayal that we're not concerned about the making them competitive with the rest of the workforce, our employees competitive with the rest of the workforce, is not accurate, at least at KU. Over the last 2 years, we went through an extensive market study, and within that market study, the intent was to ensure that we're paying our employees comparable to the industry and comparable to the region. And as we finished that, we brought 33% of our workforce wages up in order to make sure that we were balanced. Naturally difficult to do in a tight fiscal environment, but the right thing to do. As part of that process, I would point out that even employees that we raised their salary as we did a review, if they went from an exempt to a non-exempt status, that was more important to them losing their exempt status than the fact that that they had their salary raised. And so, as Mr. Passantino has pointed out, we have found, as we look at this particular issue, that there are morale issues associated with it. The scope of those morale issues, we're not even sure of at this point. One last thing, and I appreciate the opportunity, is we've talked a lot about our basketball coach and his salary. Mr. Self is not paid with state funds, and therefore I think a lot of the comparisons of what reducing his salary would do for us is not necessarily germane. So,
University of Kentucky chose this year to take athletic funds and build an academic building with it as well. So
The gentleman's time has expired. Mr. Hinojosa.
Thank you, Chairman Klein and Ranking Member Scott. Today's hearing on the updated overtime rule by the Department of Labor is long overdue. According to the Economic Policy Institute, an estimated 4 million workers would benefit from the proposed overtime rule, and it would help more than 1.2 million working people in my own home state of Texas. Critics of this much-needed final rule also argue that colleges and universities cannot afford the increased costs. These educational institutions, like all other entities, will have a number of ways to come into compliance with the rule, including raising employee pay, limiting employees to 40 hours a week, paying overtime on top of an employee's salary as needed, or any combination of the above. Additionally, many employees at these colleges are exempted from coverage under the FLSA. It seems to me that we must be realistic about the number of people affected here. I think back to 20 years ago when I was elected to come to Congress. I was looking back on the computer and saw that 1996, when I was elected, the minimum wage was $4.75 an hour. Under Bill Clinton, in his second term, ending his second term, we were able to pass an increase of the minimum wage, and it went in several steps. It reached $7.25 in 2009. That's 9 years ago. No, 7 years ago. But it was interesting to me that the same arguments that I hear my friends on the other side of the aisle, that businesses will close and things will go to hell, just didn't pan out. That is not what happened. What happened is that in the second term of Bill Clinton, we had a surplus of $600 billion. We balanced our budget. It was a period of prosperity because we raised the minimum wage, plus many other things that occurred under Clinton's second term. So what we're being told now, same excuses for not changing the minimum wage in about 12 years, to me is hollow. It's not true. It seems to me that we've got to be realistic and that we've got to do something. I request unanimous consent, Mr. Chairman, to submit a letter from over 250 professors at colleges and universities across the United States, and they strongly support the Department of Labor's new rules governing overtime.
Without objection.
Thank you, Mr. Chairman. Mr. Rounds, I've got a couple of minutes, and I want to ask you, according to your cost estimates, assuming they're correct, your cost of this proposed rule will represent 0.7% of payroll costs in 2015. It would represent 0.3% of total operating expenses, and about 50% of what USA Today reports is the annual pay of Kansas University's head basketball coach. Why do you think these small percentages will require such a drastic reduction in student services?
Thank you. I appreciate the question. I'm answering the question is what I'm looking at is the individuals who are primarily affected. And you look across the individuals who are impacted, a large percentage are individuals who work directly with our students. And as you look at the different numbers, what I'm aware of is the fact that we're on a very fixed and tight budget, and it would be difficult or impossible in order to those individuals that are directly associated with providing services to our students in order to be able to adjust their salaries to make them
Thank you, Mr.
exempt.
Rounds. My time is almost up, and I want to say that I respectfully disagree with you. Goldman Sachs says this morning, new Obama rule on overtime likely to add 100,000 jobs to the economy. I think that that's more likely to happen.
And the gentleman's time has expired. Dr. Fox.
Thank you, Mr. Chairman, and I want to thank our panel, all of them, for being here today. I do want to say that I think some of the information being presented here comes from folks who live in an alternate universe where they've never worked in the private sector. Recommendations coming in from folks who've never worked in a private sector and have no idea what it cost in addition to the direct cost to comply with such government rules and regulations. And I want to say that Dr. Bernstein said everybody should be paid fairly, and I agree with that. But there are many people in this country, Dr. Bernstein, who work in nonprofits who don't do it for the money. As Ms. Sharby has said, they do it out of a sense of mission. And they make that choice when they go there, just like we don't pay our teachers enough in this country, in my opinion. But they know when they go to those jobs what the pay is going to be, and they do it out of a sense of mission. And I think that's perfectly fine. We need to continue our civil society, organizations outside the control of government who have that sense of mission. It's part of what makes us such a great country. Mr. Passantino, I think that General Rounds was getting to this point, but I'd like to ask you if you would talk a little bit about the areas where the Department of Labor may have underestimated the cost of compliance with this, because we know historically these government agencies, again, live in an alternate universe and have no idea what it costs to implement the rules and regulations. Would you say a little bit more about the cost of compliance for these rules?
Sure, and I think a lot of the cost of compliance is not simply complying with this rule, it's what this rule forces employers to do in the context of other regulations. So it's not simply, do we look at the increased salary and what that increased salary level does to a particular employee and whether that's an added cost, and whether as a result of that employee getting a raise, that employee's supervisor then has to get a raise, and that's an additional cost. You also have to look at the overtime payments that are going to be made to the employees who are reclassified as non-exempt. You need to look at the cost of implementing timekeeping systems. You need to look at the costs of additional, frankly, legal advice and HR work to determine what's compensable, what's paid time for employees who are not used to keeping track of time, who are not used to punching a clock, who have the freedom to use their computers at home and mobile devices. And for the first time, these employers are going to have to make decisions on whether that's paid time and where the particular time begins and ends.
Great. And I want to follow up a little bit on the adequacy of keeping records. The Labor Department's guidance accompanying the final rule says there's no requirement that employees punch in and punch out. You talked about the challenges of sitting in the school pickup line, for example, and sending out emails or answering a telephone call before work, after work, miscellaneous things that all of us do. But to that point, the guidance specifies for an employee who works a fixed schedule, an employer need not track the employee's exact hours worked each day. But considering the ever-increasing threat of litigation on the wage and hour front, is it ever advisable for employers to forego tracking hours for overtime eligible employees?
I mean, it's a huge mistake to say we're not going to track those hours. Sure, if somebody is always going to work 9 to 5 every day, the rule says you can keep track of time that way, and they can mark a box that says, yes, that's what I worked today. Given the nature of the employees who are going to fall in this reclassification, given the nature of the workplace and the reliance on electronic devices, given the fact that there are lawsuits filed each and every day over 6 minutes here and 6 minutes there, it's a mistake not to keep track of those hours religiously for employers to make sure that they are capturing, whether somebody works 8 hours or whether they work 8 hours and 6 minutes.
Thank you very much. And in my last 13 seconds, I want to say to Ms. Sherby's comments, she points in here, Easter SEALs cannot afford to pay overtime, and the children with disabilities we serve are the ones who will suffer the most. And I think it's really important that we understand the most vulnerable in our country are going to be punished by these rules. Thank you, Mr. Chairman.
Gentlelady yields back. Ms. Bonamici.
Thank you very much, Mr. Chairman. I see the Department of Labor's overtime rule as a long overdue update, and I think, Dr. Bernstein, you made clear in your testimony with your chart that it's long overdue. According to your testimony, back in 1975, more than 60% of full-time salaried workers earned salary levels that qualified them for overtime pay. Today, it's only 7%, and with this increase, it'll only go up to 35%. According to the Economic Policy Institute, in my home state of Oregon, about 124,000 people will benefit. Talking about this rule, Nikolai from Oregon said, I have worked an average of 55 hours each week for the past year. But since I've been salaried during that time, I have not been eligible for overtime pay. This new regulation would mean a raise of about $10,000 a year for me, which would allow me to invest in education and build my life and my family. Across my state of Oregon, there are many businesses that are recognizing they can offer workplace fairness and balance for their employees and still continue to prosper. In fact, I just attended a few days ago an event called When Work Works. That was sponsored by Family Forward Oregon and the Center for Parental Leave Leadership. And at that event, they recognized many of our forward-thinking employers that have been really leading the way and providing their employees with a fair pay, flexible and positive workplace policies. And they reported that these policies have helped them tremendously, not only with their bottom line, but with recruitment and retention. Now, some have said that complying with this overtime rule is going to reduce flexibility for employees. I'm going to ask you about that, Dr. Bernstein, but I don't find that argument persuasive. The Economic Policy Institute report noted that both the hourly workers now and salary workers making less than the new threshold say they have little control of their schedules now anyway. In fact, working people, they can't have their kids or their parents schedule their illnesses around their employer's convenience. It doesn't work that way, and these are people who cannot afford to forfeit their hard-earned pay. So under the Fair Labor Standards Act, employers can allow workers to alter their start and end times. They can get advance notice of schedules to take time off, and the overtime rule doesn't change that. And in fact, to provide flexibility, we should be working on, in this committee, the Schedules at Work Act, for example, and the Family and Medical Insurance Leave Act. These would truly provide workers with the flexible and predictable schedules, as well as joining the rest of the world in offering paid time off. So, Dr. Bernstein, I mentioned the flexibility argument that we've heard here today. Can't employers still offer as much flexibility and predictability under the new rule as they could under the old rule? And can you describe what this flexibility would look like from the perspective of both the employer and the employees?
Yes, I can, and I appreciate the question because I think, once again, there's been a great deal of misleading comments made today suggesting that some of the nuances in the rule are not well understood. One of my colleagues mentioned that the rule will force employers to move workers, I quote, from salary to non-exempt status. That's simply not the case. Workers can absolutely remain salaried workers under the new rule. I'm sure Mr. Passantino will back me up on that. It does mean, of course, that those workers will have to be paid overtime per hour if they are if they are within the threshold, but there is nothing that says a worker has to be moved from his or her salary status. There's also been a tremendous amount of assertion here about morale and flexibility. I think we would be well advised to stick to the research on that and maybe tone down some of the assertions. I'm not sure how it helps morale to pay people $0 per hour for overtime, especially when we're talking about considerable numbers of hours, as we've heard from some of the members today. But if we look at the research by Dr. Lonnie Golden, an economist who looked at this question, he found that contrary to a common assumption, salaried workers at the affected pay levels appear to have no more ability to take time off for personal or family matters than do hourly workers at that same annual earnings level. Salaried workers at the affected pay levels, so at the levels affected by the new rule, either report greater work-family conflict and work stress, or report greater incidence of the conditions associated with conflict and stress, as do hourly workers. Unfortunately, when it comes to flexibility and morale, there's not a lot of difference between somebody who's hourly or salaried if you're barely getting by. If you're a middle-class family earning the current threshold, $24,000 or $25,000 a year, as has been said, you're near poverty. If you're at the new threshold, you're below the median earning. So whether you're salaried or hourly, morale and stress is a huge issue for you that is resolved when you no longer get paid $0 per hour for working overtime.
Thank you, Dr. Bernstein. My time has expired. I yield back. Thank you, Mr.
The gentlelady yields back. Mr. Carter, you're recognized.
Thank you, Mr. Chairman, and thank all of you for being here today. I'm going to start with General Rounds. General, first of all, thank you for your service to our country. I had the privilege of serving as chair of higher education in State Senate of Georgia when I was in the state legislature. So higher education is very important to me, and I want to know the impact that this is going to have on higher education. In fact, I think it's only appropriate that this committee know the impact. After all, we are education and workforce, and after all, we have dealt and continue to deal with increased student debt. We've continued to deal with all of the things that do with student loans, and those are things that are very important to us. I want to know because the American Council on Education released a statement on May 17th talking about the effects that this could have on higher education, and I quote, "It could have a combination of tuition increases, service reductions, and possibly layoffs." Do you find that to be true, General Rounds?
I do find all of those assertions to be possible. And one of the things that I would like to read that I have available is a statement from our Vice Provost, who is responsible for providing student services. And I think this is very compelling. What he says is what the new rule really does is impede our ability to customize and personalize the educational process beginning from the time a student initiates an inquiry to the time they depart or graduate. The level of personalization or customization has been a source of sustainable competitive advantage for us in a highly competitive environment, as we have emphasized and benefited from focusing on the relational versus the transactional aspects of the work. This rule directly impedes our ability to build these relationships. In addition, I think it is a direct contradiction to the national completion agenda, as a student access to and availability of academic and support personnel and services will be reduced. KU needs to highlight that decreasing services is more than reducing operating hours. It will have a profound impact on the ability to attract, retain, and graduate students. And again, that's tied to the individuals who work with students on a reoccurring basis, many of them who are impacted by
absolutely, and we understand that, and that's one of the things that we're most concerned with. Ms. Sharby, I want to ask you, you're an HR specialist, you're an expert at this, years of experience and much expertise. How is this going to impact you as an HR person? Now, I want to know, you have until only December the 1st to comply with this. I mean, obviously, it's going to have a big impact.
Well, the biggest impact that we have right now is trying to develop a communication to our employees that we are going to have to change from exempt to non-exempt status, and how to do that in a way that they don't feel diminished. They have already spoken to me saying, what does this mean to me? How am I going to do what I want to do in order to meet the needs of the clients that we serve? So that's one of our big struggles. The other thing that we have to do is we're going to have to look at alternative ways to pay our employees. Offering overtime simply is not an option.
Okay. All right. Very quickly, I got a minute and a half left. One thing that we're missing on this panel today is small business. I'm a small businessman. November 21st, 1988, I opened my first retail pharmacy. Dream come true for me. Went to 3 banks, not to compare interest rates, but instead the first 2 turned me down. The third one finally went along with it and loaned me the money. And I want to ask you, Dr. Bernstein, how many businesses have you run in your career?
Actually, I'm running one now.
Are you?
Yeah,
is it a small business? Is this going to impact you?
I have a self-employed business, and believe me, I have
self-employed business?
Correct. I am self.
So
I have
do you
a
have any
self-employed business
employees?
along. Let me finish, please.
Now,
along with
I'll reclaim my time. Are you the only
I'm
employee?
trying to answer your question, sir. Yes,
I
have.
You're the only employee.
I work for a private employer in the nonprofit sector. I also have a self-employed business where I am the only employee, and believe me, I deal with a lot of the kinds
you're not going to have to comply with the overtime rule. You don't have employees.
I would be exempt from the overtime rule.
You would be exempt.
I have been part of small businesses where I did
from the
work,
overtime rule
was
when I opened my business and when I was working not 40 hours a week, not 60 hours a week. I was working 80 hours a week. I did that for at least 5 or 6 years. The first year I made nothing. The second, the third, the fourth year I made half of what I'd been making before. Now, where were those overtime rules then? There were no overtime rules then. Mr. Bernstein, Dr. Bernstein, have you ever signed the front of a paycheck? You sign the back of a paycheck. You don't sign the front of a paycheck.
No, that's
There's
not
a
true.
big difference.
That's not true. I have various business
and I
endeavors
doubt
where
that anyone who
had to
has had an
sign
impact
front
on
of a
these
paycheck.
rules signs the front of a paycheck. They sign the back of a
Gentleman's
paycheck.
time has expired. Mr. Pocan.
Thank you, Mr. Chairman. Well, I guess I'm a little surprised that we're having this hearing with the name it has rather than something like overtime rule long overdue. Instead, we're having one to question exactly what it's about. And I do have to agree with Mr. Carter on one thing. You know, there's about 187,000 people in my district who'll get a raise out of this. I think your state, you're going to get about 493,000. But when you said it'd be good to have a small business person up here, I say that all the time. So often we get attorneys, and this time we don't have all attorneys, but often we don't get people actually impacted. And I think, you know, that is one of the questions I'd lead off with right away to Mr. Bernstein. If I understood you correctly, of the rule, are you saying, in answer to Mr. Polis's question, that it was about 0.5% of people affected are in the university arena and about under 1% in nonprofit, and the rest are small business?
Well, what I said
not
was,
small business, but other traditional business models?
I wasn't saying anything about the size of business. I was saying that the affected workers within those industries amount to less than 1%.
So do you know if the nonprofit and the university sector of employees versus other private sector, do you know what % of that is affected by this?
So in the total economy, including all sectors, less than 1% of the workforce is affected in that they are between the new and the old threshold, and they tend to work, they're currently exempt, and they tend to work overtime. That's less than 1%.
Sure. The question, though, is how many of that are in businesses other than the UW, or other than universities and nonprofits?
The vast majority.
See, that was the question, because I think that's the problem, is by not having small businesses here, it's almost like a Trojan horse, right? We're bringing in some more sympathetic industries, you know, nonprofit and universities with a part of the rule, but we're not talking about the people that think it's okay to offer someone with a family of 4 a sub-poverty wage to work overtime. And that's exactly what that current level is set at. It's a sub-poverty wage for a family of 4. So 4 million people immediately, and millions others will benefit by this rule. And yet, the folks we've brought in, quite honestly, there's other issues around. I mean, I heard you, Ms. Sharby, and I heard you loud and clear. You said Medicare and Medicaid funding, there's no increase expected in the near future. Would you like to have an increase in those funds that come to your organization? It's a simple yes or no.
Yes, I think it would be helpful.
And I think the other thing we heard was from Mr. Rounds, you were talking specifically about, you know, it's going to cost $3 million to do it, but if I understood right from some other previous comments, since 2008, there's been about is that correct, a 22% cut to KU from your state budget?
That's correct. I don't remember the exact percentage, but that's
So, you know, Mr. Chairman, I guess what I'm getting at is when we look at the macro level of
at first I think it was 354 people, and then you were just told us 92 were going to get the increase anyway because they're postdocs, they'll be getting it through NIH, et cetera. So we're talking about 262 people left, but you got a 22% cut to your budget from your state. I have a state that's doing the same thing. They just cut $250 million from the university. Let's look at the big picture here. And the big picture is we should have a hearing, quite honestly, on all these state institutions that have not lived up to their obligation to their students in publicly funded universities. I've seen articles on this. That is a much bigger dynamic than the 262 people that are going to be affected there. And Ms. Sharby, just a quick question on the 0.25% of your budget that you're going to need to comply with this. Does that affect people in all 4 states or just New Hampshire?
All 4 states. And
so in 4 states, we have the opportunity to give people a wage who work for your organization for a really small amount of money. So I think the whole contention around who we have here before us does not really address the fact that there are a lot of small businesses out there, and not even small, it's big businesses who, fast food, et cetera, are paying people, again, at sub-poverty wages that would have to work and not get paid for overtime for a family of 4. That's the real issue. And having this increase, Mr. Bernstein, if I remember right, for decades, if adjusted for inflation, wasn't the rate about $1,000 a week that was previously out there?
If you go back to 1975 and you put it in today's dollar, the threshold was $1,100 per week, about $58,000 per year. And if I may make one quick other comment, I think it would be a mistake to assume that the general perspective of nonprofits in higher ed is represented on this panel today. There are 2 statements out today, one from representatives of higher ed, one from representatives of nonprofits, very much in support of this rule. So our draw today was very much tilted towards higher ed and nonprofits who are against the rule. But don't be misled, because there are many of those institutions that are very supportive.
Yeah, and thank you for saying that, because I know there's a list of, I think, a few hundred folks, organizations that are supporting the rule as well. I'll yield back my time.
Gentleman yields back. Mr. Allen.
Yes, thank you, Mr. Chairman. And, of course, I come from the small business world as well. And what my understanding was, as far as salaried employees, was that was something that you did to reward them for their achievement. In other words, you guaranteed them basically 40 hours a week of work, and they could count on that salary. And then, of course, we also had incentive pay. If they perform beyond their expectations, they receive compensation as well. And many times in our business, the compensation exceeded the actual salary. And, of course, there was they didn't punch a clock. I mean, their time was their time. And so now I'm assuming what we're going to do is we're going to have this compliance issue as far as these people are concerned. My biggest concern is the growth of this economy. And, the economy, it's not growing. It's as part of economic study incorporated with this rule, it was discovered that many employers will potentially decrease employees eligible for overtime protections, base salary, and decrease overtime hours worked to compensate. In a time of slow economic growth, when the government should be promoting policy that creates jobs and grows the economy, why is DOL encouraging further regulation that will decrease economic output and overall GDP growth? Mr. Placenta, you want to answer that question?
The question as to why DOL is doing this?
I mean, at a time when our economy is basically stagnant. I mean, we're growing less than 2%, sometimes less, some quarters less than 1%. I mean, how do we get this economy to a 4 to 5% growth? I mean, I don't see how this rule is going to help.
I'm not an economist, and on a macroeconomic level, I don't have any real insight into that. What I can say is that employers who I've had discussions with recently are really struggling with how they're going to implement this and the decisions they're going to have to make whether they're going to be able to afford to raise someone's pay, whether they are going to have to reduce salary on the front end so that they can accomplish the goal of getting to the same total compensation at the end of someone's work week. I would also like to say that the concept that a salaried exempt employee earns $0 after 40 hours in a week it's a fallacy. And the simple fact of the matter is that employee earns the salary when they work hour 1. So by that logic, they also get paid $0 for hour 2 and hour 3 and hour 4, all the way up to however many hours they work in that work week. That's the point of the salary, is it covers work from when you start to when you end in any particular work week.
Mr. Rounds, as far as your university, I mean, again, you're trying to educate people to go get a good job. How is this going to affect your ability to do that? I mean, are you going to have to cut back on the number of students, or what are you going to do to deal with this?
Sir, as I mentioned, we will likely change the status of many of the employees that are impacted by the law.
So you'll
many
move
of those
them
employees,
to an hourly rate?
move them to a non-exempt status, and so that for anything over 40 hours that we have to pay them overtime. As Dr. Bernstein has pointed out, there are multiple options that we have, but the bottom line is anything over 40 hours, we have to pay them. And if that's true, many of these employees right now have very flexible approaches to doing their jobs, and those flexible approaches are tied to meeting the needs of students. And our concern is that they will lose that flexibility, and therefore they won't meet the needs of the students in the same way, which obviously reduces services and impacts the quality of the education that we can provide.
Well, I'm just about out of time. Ms. Sharby, I want to tell you how much I appreciate what the Easter Seal does. I'm a former president of the Augusta Easter Seal Board, and great work. We're actually making folks who cannot do a job, we're teaching them how to do jobs and putting them to work, and I think that's what America's all about, and I appreciate your service. I yield back.
Gentleman yields back. Mr. Takano.
Thank you, Mr. Chairman. The Department of Labor's update to the overtime rule is long overdue, and according to the Economic Policy Institute, would benefit 1,076,000 working people in my home state of California. I'd like to point out that this update would directly benefit my colleague, Mr. Allen's state, by 493,000. Nearly 500,000 people in Mr. Allen's state would benefit from this rule. The overtime rule is one of the most significant actions the administration has taken to support working families and fight income inequality. And while we can get bogged down in the details, it's important not to lose sight of the millions of workers and their families the rule will help. Workers such as Soledad, a member of Moms Rising and a mother of 4 from California. Soledad wrote in support of the rule, saying, quote, "I work as a salaried employee and always work more than my regular 40 hours a week. My usual weekly hours can amount to 50 or 60 hours a week, and I do not get paid for the extra time. Sometimes I work 12-hour days without compensation due to being salaried. This has got to stop for people that work more than 40 hours a week. Overtime takes away the quality of life with our families. We are too tired to do anything with our families and are still not being compensated," end quote. According to the Economic Policy Institute, 12.5 million salaried workers such as Soledad will directly benefit from the rule. It helps 6.2 million women, 4.2 million parents, and 5.5 million workers between the ages of 35 and 54. Well, changing gears, as we've heard this morning, the FLSA does not contain a specific exemption for nonprofit organizations, but that doesn't mean that there isn't some nuance in how the rule will apply to nonprofits. Dr. Bernstein, can you provide some examples of nonprofit institutions? Are all nonprofits small entities that are engaged in charitable work?
Some nonprofits, and this is something I speak to in my testimony, including social welfare and some educational institutions are exempt based on characteristics of the institutions themselves and the workers within them, although typically somebody in there is probably going to be non-exempt. The DOL has worked hard, however, to both provide guidance and accommodate some of these concerns. As is mentioned, for the Medicaid-funded providers of services with intellectual development disabilities, the new rule doesn't take effect for 3 years. And in addition, higher educational institutions worry about the fact that their postdocs are comforted by this National Research Award point I've been making, where NIH will raise the grant level to the new higher cap.
Okay, as a follow-up, can you talk about enterprise coverage and the types of nonprofits that are exempt under the provision?
Sure. Based on the nature of their activities and whether they involve revenue-generating sales of above $500,000, some nonprofits or individual workers at those nonprofits may be exempt from the new rule. This has a lot to do with the extent to which you're operating something that looks a lot like a business within a nonprofit. So to the extent that you're generating revenues by making sales that go over $500,000, you would be covered. But if you're not, if you're doing volunteer activities, you're not engaged in the type of work that looks like a business that would be covered, then your institution, your establishment may well be exempt.
So plenty of nonprofits are exempt, and it's just that at that $500,000 level. Thank you. It's important that we look at the numbers here. According to the Department of Labor analysis, only 1% of employees at nonprofits who will be affected by the rule regularly work overtime. Is that correct, Dr. Bernstein?
That's right.
Well, it's an adjustment, but it's not a burden nonprofits can't handle. In fact, I would like to ask unanimous consent to insert into the record a letter from nearly 140 nonprofits that write in support of the final rule and who are committed to complying with the new regulations.
Without objection.
Thank you. Dr. Bernstein, would you like to add a little more to just the idea of the number of nonprofits that can comply?
Well, I think that the points that we've heard from both Ms. Sharby and Mr. Rounds are very important in the following sense. Their problem isn't with the rule, it's with the fact that their funding has often been cut. So if you're talking about an education system that's taken a 20% cut in its support, they're going to have all kinds of problems of which this rule is the least of them. What we're trying to do here is establish fair pay for fair work, and that's a separate problem from the fact that in many ways, Congresses and state legislatures, especially in Kansas, where they've aggressively cut taxes, are underfunding their university system.
And the gentleman's time has expired. Mr. Thompson.
Chairman, thank you so much for this this hearing. To me, I've heard the word poverty mentioned a lot, and I'd be hard pressed to. I don't think there's anyone on either side of the aisle isn't concerned about that issue, isn't concerned about providing opportunities for greater opportunity, for success, for realizing the American dream, which really is greater opportunity. But the pathway to greater opportunity and out of poverty is not an arbitrary executive branch dictate. I'm sorry, it just doesn't work. Those cookie cutters rarely work. They usually wind up with unintended consequences that make matters worse for people, and that's what we're trying to defend and push back on here. To me, rather, it's really looking at a pathway out of those situations. Pathway for Soledad, mother of four that I just heard about, and I've met lots of those folks just like that around my congressional district. They need a pathway. They need something like, quite frankly, I'll shamelessly plug it, career and technical education training. And with the chairman's support, I think everybody in this committee is going to have an opportunity to talk more about that in the days to come here, hopefully before we leave, before that third week in July. And so, my first question is for Ms. Sharby, Tina. Just this past weekend, I had the privilege of speaking at the closing ceremony of the Pennsylvania Special Olympics Games, 2016 Games, which is, I love organizations like yours, like Special Olympics. I'm a longtime scouter, so I look at the hours, the evening hours, the weekends. I've been involved doing my part as a volunteer. I know how important it is to fund the mission, And I look at the good that is done, which is amazing with those resources, and I look at the quality of individuals. Last week I was at a Goodwill facility up in Erie County, and I look at the job training that goes on there. And so my question for you is, first of all, thank you for your tremendous work you do as a part of the nonprofit community. And organizations like yours, and I've mentioned some of those, Easter Seals, Special Olympics, Goodwills, the Boy Scouts of America, Girl Scouts, they help boost the quality of life for so many people and families every year. And as legislators, we should be working tirelessly to support your mission, not making it harder for you to succeed. Given the widespread presence of Easter Seals across the United States, and as a former rehab professional, I worked very closely with Easter Seals when I had a real job, is the way I like to describe it. How will the final overtime rule affect the ability of individuals to access crucial services, specifically in rural and underserved areas?
Thank you for the question. It's a really good question. I can give you the example of our care coordinators in our military and veteran services programs. The individuals that we serve work very closely with the care coordinators, and they develop a relationship where trust does not come very easily amongst that population that we serve. So we're looking at potentially having to develop an on-call system where only 1 of 8 of our coordinators would be on call for the week, because we cannot afford to pay the overtime. It's a non-funded program that we run. The concern that we have about that is now the person who needs the emergency help, maybe in the middle of the night, losing their home or thinking about suicide, they're going to call that on-call person who might not be their care coordinator. They're not going to want to talk to them. They want to talk to their care coordinator. That's where we think that the services are really going to impact the individuals that we serve.
How important is that at a time of crisis? Because that's what you've described.
Huge.
And you could cross that over to agencies, nonprofits that are facing manning suicide hotlines and services, children and youth. How important is it to get have the right person available at that time of crisis when people actually reach out?
It's literally the difference between life and death.
I don't think an arbitrary executive, it'd be a shame to see those loss of lives as a result of some executive branch action. Mr. Pesentino, the Department of Labor's final overtime rule includes an extremely narrow non-enforcement provision for entities which provide Medicaid services for disabled individuals in facilities of 15 or fewer beds. Given your expertise, can you speculate on how many employers or employees this provision would actually help? And additionally, would these employers be protected from legal action during this non-enforcement period?
I'm not sure of the answer to your first part of the question about how many will be impacted, but I suspect it's very small. The more consequential piece is a non-enforcement policy does not mean the regulation isn't in effect. It means the Department of Labor is not going to take any enforcement action against someone based on those regulations. The private rights of action continue to exist, and that non-enforcement policy does nothing to the private right of action.
So the bullseye would be put on the backs of those agencies for frivolous litigation. Thank you.
And the gentleman's time has expired. Ms. Clark.
Thank you, Mr. Chairman, and thank you to all the panelists for joining us today. I have to say, I want to go back to the comments of my colleague, Mr. Pocan, and say I feel like we are missing in this discussion some of the macro issues. Of course, it is critically important that our veterans, that the clients you serve, Ms. Sharby, are able to talk to their case manager when they are in crisis, and that the students, and we were lucky enough just yesterday to join KU in a discussion of the critical importance of funding scientific research at our incredible universities across the country, including Kansas. But it is not the overtime regulations that are going to cause a loss of life, as my colleague just stated. It is so many other economic pressures. And if we want to create a robust economy, one of the best ways to do it is to help address income disparity, to help address stagnant wages, the overwhelming cost for many families of childcare and of housing and transportation. These are the big macro factors that are coming to play and really causing a hard time for many nonprofits to deliver their critical services, of which Easter Seals certainly in New Hampshire and around the country, delivers critical services, as do our institutions of higher education. And those issues are the ones that we need to offer this critical relief. In Massachusetts, what the overtime new regulations are going to mean for working people in my state are 262,000 people are going to get a raise. That is a real benefit. That is a real help to all of you at the table. In Mr. Thompson's state of Pennsylvania, 459,000 people will be able to have a raise due to these regulations. So I think that we have to remember to look at the overall economic picture and what are those levers that we need to move to bring that relief, because I don't believe that it is the overtime rules that are going to cause your ultimate staffing and your ultimate woes at KU. Dr. Bernstein, I wanted to start large and then go to detail. But I do believe that this is a critical piece of addressing income inequality, as you mentioned in your testimony. What are some other factors and policies that we should be looking at to address that?
The minimum wage has been stuck at $7.25, as was mentioned earlier, at a federal level since 2009. Raising that would certainly help lift the fortunes of low-income workers. There's some bipartisan support for another idea that would help low-income workers, which is expanding the earned income tax credit to reach childless adults who now get very little from that. In terms of tightening up the job market, we really could use a deep dive into infrastructure investment. The erosion of unions has really hurt the bargaining power of lots of middle-class workers. But I very much take your point about the connection to the overtime rule as well. As you remember, the chart from my testimony shows that when inequality was a lot lower than it was today, the threshold was a lot higher, and vice versa.
And specifically, I also think that one of the pieces here that we are going to help address is the pay equity gap for women. What do you see the role of these new rules in helping with that as well?
Well, a slight majority of those affected by the new rule are women. By the way, a much more significant majority affected by a higher minimum wage are women, because women are disproportionately low-wage workers as well. So I do think that this is a help in terms of gender pay equity. I would also note, not on the gender side, but Mr. Rounds might appreciate this, according to DOL numbers, 80% of the workers, of the affected workers helped by this increase, have at least some college education. So it's actually a real boon to the people that KU and other institutions are training, sending out into a workforce where they will be compensated for their overtime by dint of the new rule.
And I've certainly heard, I appreciate you mentioning the minimum wage. It's something I certainly support. But we also have to look beyond that and look at our higher and mid-income earners. And I think that this gets to that point. Thank you very much, and I yield back.
The gentlelady yields back. Mr. Grothman, you're recognized.
Okay, I'm sorry. I'm updating my notes here. I'm just finishing up on the questions of Congressman Takano, and I got to talk to him later about how many men are going to be helped by this new rule. Maybe I missed it. Okay, questions. I'm trying to think how this rule would impact, when I look at past jobs I've had. I've heard from the golfing industry, but there are a variety of jobs that you have that's a lot busier one time a year than another time a year. Maybe it gets busy at the end of the year. Maybe it gets busy during tax season, whatever. And you know it when you go into the job, there's sometimes you're going to be working 50 hours a week, and other times you might just be hanging around the office and not getting a lot done. We'll ask the expert on the bill. Dr. Bernstein, how do you think this affects how those sort of jobs work? If I hire somebody knowing that some days going to be super busy, other days not so busy, I think it's going to kind of mess up those businesses and kind of hurt those employees. What do you think about that there?
Well, I disagree. I mean, I think you have to look at the record. Certainly the last time we increased the threshold, the slight increase in 2004, you can see that on my chart, we didn't see those kind of impacts. I do think that when it comes to people with variable schedules, as you suggested before, remember the rule doesn't get invoked until they cross 40 hours. So there are ways to, I think, work around that for employers.
Right, well, not to cut you off, I think there are jobs in which you're expected sometimes to work 55 hours a week, and other times you can take off and work 28 hours a week. And that's the nature of the real world. You know, there are times that are busy, times not so busy. You know, getting involved, you're a salaried employee. There's sometimes I'm going to work when I get it done, and sometimes I don't. It seems it's going to make it very difficult for those sort of working
Again, I mean, I think you make great points, and I agree with the way you characterize this. But if you go back to the 1960s, 70s, remember the threshold was $1,100 in today's dollars, and the unemployment rate was lower than it was today. Productivity growth was faster. So there's no evidence of the kinds of disruptions that you're suggesting.
Okay, I'll give you another thing that concerns me when I think of people in these jobs. What it's going to do is it's going to put pressure on to get out the door at 4:30 or 5 o'clock or whatever. There are times where you're working on a project where you might say, geez, you know, in another half hour, I might get this right. I just want to make sure I get it done right. Instead, you're going to get pressure from your employer to get out the door. Are you afraid it's going to result in a worse work product? Because this is what's going to happen.
Well, again, I mean, if we're talking about the kind of workers you're talking about, sound a lot to me like people like myself and maybe yourself as well. And, you know, we're exempt, so that's not really relevant.
No, all sorts of people under $51,000 want to get their want to get their job done right. Okay, if I'm making 46 grand a year and I'm hired to do something and I feel things aren't getting done right and I want to hang around another hour to make sure that report is right.
So I guess I don't see anything inconsistent with what you're saying. And again, I think you're raising great points in the idea that that worker has to be paid time and a half for that extra hour because there's something called the 40-hour work week that was enshrined in the Fair Labor Standards Act of 1938 and is more relevant today than it was then, in my view, given the issues around around bargaining power and the extent to which middle wage workers have been hurt.
Look, if I have a job, I want to make sure I get those things done right, okay? In part because of the customers, in part because of my boss. Okay, what you're doing here, or the people who put together this rule, are you're creating an environment in which the boss feels you better get out the door at 4:30. So it puts your employee in a position of which either I submit the report on a so-so, not sure it's right basis, or get my boss mad by hanging around to 5:30 to go over it again to get it right. I mean, there's certain jobs that are salaried by nature, in which you work till you get it done. Aren't you afraid you are putting those employees in a bad situation? If I'm an employee like that, I want to hang around that business as long as I can. I want to grow with the business. I don't want to be in a position in which I have to choose between turning in a lousy report at 4:30 or getting my boss mad at me because I had to hang around till 5.
Like, with respect, I think we have to distinguish between the kind of compelling story you're telling me and the actual numbers about who's going to be affected here. We're talking about 0.03% of the national payroll. Now, you may just believe that we shouldn't have a 40-hour work rule for covered workers under the FLSA, and that's just a fundamental disagreement between us. But in fact, the economy has performed perfectly well with thresholds far above today's levels.
I'll give you another question. It occurs to me that what's going to happen here is you're going to make the workplace less friendly. Okay, right now I think sometimes people may hang around past 4:30. Maybe it's a more easygoing workplace. Maybe at the end of the day, employees are talking with each other about who knows what, and they know they can hang around till 5:30 and 6 and get the job done if they have to, or 5:15. They can talk about, I don't know where you're from here, the Redskins or whatever. Instead, it's going to be, we have to get out the door by 4:30. Don't you think it's going to make kind of for a less friendly, more intense
environment? All right, the gentleman's time has expired. Ms. Davis.
Thank you, Mr. Chairman. And just sort of sticking with some of the flexibility issues there, because I think that we have a notion that somehow because we're in the 21st century and that we do use electronics and we do provide different ways of flexibility, that this would all stop. And you know, Dr. Bernstein, you were starting to comment on that. Can you tell us why is that not going to be the case?
Well, I mean, I guess I would say, first of all, just kind of following up on the discussion we were just having, it doesn't really create a flexible or high morale or welcoming workplace when somebody is misclassified as an exempt worker because they're called an assistant manager and they work 5, 10, 20 hours for 0 extra pay when they should be getting time and a half overtime. And in fact, as I've discussed earlier in my testimony, instead of kind of assertions about these flexibility issues, research done by Professor Lonnie Golden has found that if you actually look from survey research at the kinds of flexibility, the sort of work-family balance flexibility that hourly and salaried workers have at around the cap, around $50,000, it's about the same. So there's no evidence that moving someone to, from a non-exempt to exempt coverage would reduce their flexibility. What it would increase is their pay when they work overtime, and that's critically important.
Yeah, I think one of the points made also with the NIH is that many of our young scientists are going to be affected in a more positive way with this new rule rather than negatively. And I think
that's a good point. I've talked to at least one postdoc who says he likes the rule a lot, in no small part because the NSF, as I've mentioned, is raising the grant level to meet the higher cap.
Right. One of the articles, the New York Times had an article just the other day, and you all may be familiar with that, talking about the Prada economy or the Prada industry, and the fact that we do have a lot of low-wage but high-potential jobs that young 20-somethings, for example, might be willing to take, and they're obviously engaging with people in a way that pushes them. I mean, they want to show their aggression. They want to show that they're ambitious, and they're going to stay on the job just as long as they can in the hopes of looking good, quite frankly. And that's what people do, and that's perfectly acceptable. But we also know that those kinds of jobs may possibly affect demographics differently by those who can afford to do that more than those who can't. Maybe young people can do it more, especially if they have a lot of support at home, versus people who have a family at home and trying to work in that fashion doesn't suit them. Do you think that in fact, as we're looking at these issues, that some of these new overtime rules could possibly change the socioeconomic diversity of the workforce in this so-called Prada industry?
Well, I certainly think it's possible, and I think it's important, and I don't know that we've quite gotten to this in the hearing so far, to note that the rule will disproportionately help some of the types of workers you're talking about. Black and Hispanic workers are disproportionately affected. They're 21% of the salaried workers, but 28% of those who would directly benefit from the new threshold. And millennials between the ages of 16 and 34 will also disproportionately benefit. They're 36% of the affected group and 28% of the workforce. More than a third of all workers with less than a college degree will be directly affected, and that will also help over 7 million children. And as I mentioned, there's a slight majority of the workers who are helped who are women.
Right. And what is the benefit of that, of diversifying?
Well, I think there's a tremendous benefit to that diversity. If I may wax philosophical for a slight second here, I am struck by the fact that we're now in a country that has twice elected an African-American president, now has nominated to a major party for the first time a woman. I think this type of diversity is extremely healthy. And I also think that the extent to which minority workers have been hurt through the erosion of labor standards, whether it's minimum wages or the overtime threshold, can't be over-exaggerated either. And this rule is an important correction to that.
Mm-hmm. Thank you. I appreciate that. And I know that others have talked a little bit about the work-life balance and whether there is something to be said for having people be more productive when that work-life balance does come into consideration. Would you all agree that there is something to be said for that?
I would.
I see some nods, but okay, all right, thank you. We do need to, I think, realize that in some ways, this really is forcing people to manage productivity in businesses, and that's something that I think can be very positive for all of us.
Gentlelady's
Thank
time
you, Mr. Chairman.
has expired. Mr. Rokita.
Thank the Chairman. Mr. Pasantino, what do you think the best way is to manage productivity in a business?
To let people work?
manage to a profit motive, perhaps?
Sure, I mean, they want to be
Manage
profitable,
to
that's the point of the business, isn't it?
Efficiency, manage
Sure.
to effectiveness, those kinds of things. And those principles apply to urban areas as well as rural areas, I guess, correct?
True.
I represent a lot of rural areas, a lot of suburban areas, a lot of small towns I'm very proud of and are great places. What's the effect of this rule on places like that?
I think it disproportionately affects those rural, non-urban areas. We've already seen clients who have, it's the same position, it's the people are performing the same work. So there's no question that the duties qualify for the exemption, right? So the duties test hasn't changed. They're exempt now, they'll be exempt under the revised salary test, but some of their workers work in urban areas and earn in excess of $47,000, and some work less, or sorry, earn less because they live in rural areas. So what you have is the same exact position, and people earn above and below the new threshold, which fundamentally indicates that not everyone earning under $47,000 is not performing exempt work. There are plenty of people under $47,000 who are performing exempt work, which is sort of the point of the salary test. The salary test is supposed to screen out all of the clearly non-exempt people, and then you go to the duties test to figure out whether they meet the rest of it. So what you have is a situation where you're including people who clearly meet the duties test, and now employers have to decide what's frankly not a great decision. They either have to raise everybody up to that 47,000, which means that they're going to have to raise the people over 47,000 as well. They can convert the entire workforce to non-exempt in that position, which is not the best solution for them. Or they can have a split position, and they can have some people being non-exempt and some people being exempt, and that's a recipe for disaster.
Yeah, because in your experience inside that workforce, folks that you represent, what would that do?
Well, you're going to run into situations where the exempt person can stay until 5:30 or 6 o'clock and get the job done.
Yeah.
The non-exempt person is going to be limited in their overtime hours.
And to Mr. Grothman's earlier point, that can't be good for morale. I mean, that can't be good for running a business or working
right.
at one like that. Yeah. Ms. Sharby, you're nodding your head. I'll indicate that for the record. You want to add something?
Well, I struggle because I'm honestly not sure how Easter Seals is going to be able to absorb these changes. We run with maybe a 1% budget margin, the difference between being in the black and being in the red. So,
And just to be clear in my opening comments, you're a nonprofit.
Nonprofit.
So the quote-unquote profit motive is the ability to stay in business, right?
Correct.
If you're not making positive revenue,
if
profit
we're
or
making-
nonprofit, you can't be there, right?
Correct. And currently in the state of New Hampshire, we have a 2.6% unemployment rate. So it's not a matter of saying that I'll bring in more employees and not pay the overtime. I just don't have any employees to bring into the state. So the morale issue with our staff is significant. We have people who feel that, just yesterday said, what does that mean to me? I'm used to going and helping out at certain events. I like to go to some of the kids' birthday parties or some of the kids' graduations.
Can't do that.
I can't pay you to do that now.
Yep.
And that's really very tough to be, and it impacts the quality of the services that we're able to provide.
Yeah, and so my question about the rural nature of my district, I think, correct me if I'm wrong, either the two of you that spoke already, applies regionally.
Right.
I mean, there's differences in regions of this country that, rural or not, that would, what you're testifying to would have the same effect. Is that correct, Ms. Sharby?
That is correct. So if a average salary in New Hampshire is $35,000, and we used to have business in New York, that same salary would equate out to a little over $50,000 in New York, but yet New Hampshire is forced to comply with the higher salary.
Unbelievable. Mr. Pastino, last word.
No, I think that's exactly right. You're going to see differences in how people are treated based on where they are, or employers are going to have to make some very difficult decisions.
Central planning at its worst. I yield, Chairman.
Gentleman yields back. Ms. Adams.
Thank you, Mr. Chairman, and thank you for your testimony. The Department of Labor's update to the overtime rule is long overdue, and according to the Economic Policy Institute, it would benefit 425,000 working people in my home state of North Carolina. I want to begin by asking Mr. Pisano, you served in the Labor Department under President Bush. How much time were employers given to comply with the 2004 change to the rule?
I believe the effective date on the 2004 rule was 120 days, but that rule was really catching up, fixing some issues that had existed in the salary test. There were 2 tests at that time. One of them was basically non-functioning. No one used it. So it really was a catch-up, whereas this is clearly jumping over a large number of people who perform exempt duties, and so it's going to be far more difficult under the current rules for employers to come into compliance.
But the current rule, though, does provide an additional two months to come up with compliance, which was beyond what the Bush administration provided for. Isn't that correct?
The current rule provides approximately 6 months, I believe, for employers to get into compliance.
Okay, so that's more. Mr. Bernstein, we talk about better outcomes for employees. You've made some comments about that. Can we, with the better outcomes for employees, can we expect that this will lead to better outcomes for employers?
Well, certainly in the past, as I've mentioned, and in fact, I would take issue with one of the things my co-witness, Mr. Pastino, just said. The new rule simply partially replaces the extent to which inflation has eroded its value since the mid-1970s. If you look at the value in today's dollars of the overtime threshold, the level, it would have been about $1,100, $57,000, $58,000 per year. Now we're talking about $913 per week, or about $47,000 per year. So it is a partial adjustment. And in fact, to speak to your question, when the rule was in effect, unemployment was low, growth was GDP growth was faster than it is today, productivity growth was faster than it is. I don't know that worker morale was negatively impacted at all. In fact, one of the things that numerous analysts predicted from looking at the rule, based on past history, not based on assertion, not based on what you think might happen, but based on research driven by what's happened in the past when we've changed thresholds, the expectation is that there will be some number of new jobs created at straight-time pay, maybe 100,000 according to Goldman Sachs, maybe 150 or so according to the National Retail Federation. I think this is positive for the economy, and I think it's positive for the workplace.
Thank you. Mr. Rounds, and thank you for your service, sir. You mentioned that workers cared more about their exempt status than getting paid for the time they work. Well, I find all the discussion around higher education fascinating, because I served 40 years in academia. But you know, the people that I talk to really find it demeaning and demoralizing to be asked to put in extra hours at work for no pay. What would your response be to that?
First, I'd like to say thanks for your service in academia. Obviously, it's essential to the country, and we appreciate your willingness to work in the academic sector. I would say that as I look at the employees at the University of Kansas, and I look at the ones that we're talking about, who are primarily responsible for providing services to students, the ones that would be impacted by this legislation, is that their passion is for positive outcomes for students, and they will lose some of their workplace flexibility, and their lack of ability to meet the needs of students will be of great concern to them. And so, as I've talked about in my testimony, is I think that that's most important, is the culture of higher education and being able to serve our primary customer, our students, and that will be eroded.
Thank you, Mr. Chair. I believe I'm out of time. I yield.
Gentlelady yields back. Mr. Jeffries.
Thank you, Mr. Chair. Mr. Passantino, would you agree that the 40-hour work week has become a classic part of the American dream?
I don't know that I would describe it as that.
So it was enacted into law in the late 1930s as part of the New Deal, which was part of the effort to make sure that we have a more even playing field in terms of working class, middle class Americans, correct?
It was enacted in the late 30s, I think, to make it more expensive for people to work more than 40 hours.
You think the objective of President Franklin Delano Roosevelt was to make it more expensive for people to work more than 40 hours a week? That was his objective as part of the New Deal?
The second part of that is that that makes more people work for the same amount, so you can pay it at straight time.
Right. So now you were part of the Bush administration, correct?
That's correct.
And do you think that President Obama and his administration, his policies, whether that's the Affordable Care Act, whether that's the Dodd-Frank legislation that was passed into law, whether that is this overtime rule, have been job killing?
Have they been job killing?
Right.
I think that they have.
They have?
Yes.
So you spent time in the Bush administration, which brought us, two unfortunate wars and tax cuts to benefit the wealthy and the well-off, but also, presumably, you made your best efforts to be part of an administration that was going to improve the employment situation in this country, correct?
Correct.
But during 8 years under President Bush, we lost 650,000 jobs, correct?
I don't know the figures.
Okay. And under President Obama, 7.5 years, we've actually gained 14+ million jobs in the private sector, correct?
I don't know the numbers on that either.
But you're here as an expert to talk to us about employment and the impact of this rule, and you don't know these basic numbers, including the ones that relate to your time being spent in the Bush administration. Is that your testimony?
My testimony and my expertise is on advising clients on how to deal with these issues, and so on a very micro level, I have a very good understanding of how that works. On a macro level, I don't have that data.
Right. So on the micro level, you think that the 40-hour work week, which is working 5 days a week, presumably Monday through Friday, 9 to 5, is not part of the basic tenet, the basic American dream in terms of being able to work hard, earn a good living, but also be there as a father, as a mother, as a son or a daughter to a parent or grandparent who may be ailing, to have a good work-life balance. You have a problem with that?
I believe that I'm living the American dream, and I'm not subject to a 40-hour work week. So yeah, I think it's possible that the 40-hour work week is not an inherent part of that.
Okay. Mr. Rounds, thank you first for your service in terms of working in the academic realm. Obviously, higher education is incredibly important. A few things that you talked about that in the limited time that I have I'd like to touch on. You said that the University of Kansas is a not-for-profit public university, correct?
That's correct.
And so presumably, what you ultimately strive to do is to provide some form of public benefit to your students, but also in the context of being part of the state government out in Kansas, correct?
Correct.
And you said 262 employees of Kansas University would be impacted by the overtime rule, is that right?
Actually, 354. 92 of those are postdoctoral employees who we have made the determination to raise their salaries to the new threshold.
Okay, so that means that they're actually going to be able to put more money in their pocket at the end of the day that will either go into the economy or go to the benefit of their families. Is that right?
That's correct, but at the same time, as we looked at the fixed grants that their principal investigators are responsible for managing, is the concern, and this has been also expressed by the Postdoctoral Association, is we're not going to be able to maintain the same number that we've had in the past, which you could argue will have an impact on research.
Okay, I would simply say I think KU is a great university, great basketball program. It does interest me that I believe Bill Self earns about $230,000 directly from the university, and as I understand it, $3 million in total in salary, and that the chancellor of the university earns approximately $510,000 per year. So I think maybe there needs to be a reassessment of priorities before the complaint is directed at the effort by the Obama administration just to make life better for working families.
And the
I yield
gentleman's
back.
time has expired. All time for questions has expired. I want to thank the witnesses and turn to Mr. Scott for any closing remarks he might have.
Thank you, Mr. Chairman. As the gentleman from New York just indicated, in 1938, Congress established 40 hours as a normal work week, and if you make more than that, you're supposed to get time and a half. After 40 hours, if you work more, you're supposed to get more. The law covered about 60% of salary employees back then, but with because we haven't updated the law as we should have, now only 7% of salaried workers are covered. This new regulation will increase it to 33%. We've heard a lot from colleges. We haven't heard enough about all of the exemptions in colleges, teachers, grad students, many coaches, many academic administrators, all hourly employees not affected by this law. In fact, Department of Labor estimates that only 3.4% of college workers will be affected, and 0.5, 1/2%, would be both affected and usually work overtime. 1/2% of college workers. Now, to honor the 40-hour work week, you're only talking about 1/2% of workers. They'll get a little extra when they work over 40 hours. We've also heard from Easter Seals honoring the 40-hour work week. Rather than working people without pay after 40 hours would cost less than 1% of the budget. Suggesting that people are going to die because you can't work people more than 40 hours is obviously absurd. And also, you could be more honest. If you expect them to work 60 hours a week, you can restate their salary, expect them to make the overtime, and they would get the eventual salary that they're expecting to get. But it'd be more honest to say what it is for the 40 hours, and then more than that after that. Now, some of this committee think that we should honor the 40-hour work week, and if people work more than 40 hours, they should get paid for the additional hours. The rule means, as I said, 1/3 of salary employees will benefit from the 40-hour work week, up from 7%, but way under the 60% who were covered in the 1970s. And incidentally, businesses, colleges, and nonprofits complied with those regulations without complaints. And so, Mr. Chairman, I hope that we will honor the 40-hour work week. We actually ought to get above the 33%. I would have hoped they would have done more, but they've done what they've done.
And the gentleman yields back. I thank him for his comments. It's been a good discussion today. I'm always fascinated about how we hear statistics here. We've had a number of my colleagues on this side of the aisle have been citing how many more people are going to get raises and works from a far left-leaning think tank, but that's just the world that we live in here. I very much appreciate the expertise of the witnesses here. You're all very, very fine witnesses. I, and most of my colleagues on this side are entirely for people getting fair pay for their work, but we have great concerns, as we heard from some of my colleagues today, that this rule is going to have a negative impact. And I appreciate Mr. Pasantino's talking about the differences, I think, in response to maybe Mr. Rokita's question, and Ms. Sharby as well addressed it. You have very different pay scale in Manhattan than you do, for example, in La Center, Minnesota. And so $47,000 means one thing in one part of the country and something else in another, and this rule doesn't recognize that demographic difference. Anyway, thank you all very much for the witnesses. Yes, Mr. Scott.
Ask unanimous consent to submit for the record a fact sheet from the Economic Policy Institute that shows effect on jobs, hours, and salaries.
The aforementioned left-leaning think tank. And without objection, it will be entered. And I thank the witnesses. We are adjourned.